Well, unless under compelling circumstances, I was mentioning this matter. Lordship will kindly recollect. I was mentioning this matter for the extension of interim order since Tuesday. Lordship was, yes, original side matter, that matter. Lordship was kind enough to direct me to come back on Wednesday. Now, in the meantime, I have filed an application that is appearing today as item number 2 for the extension of interim order. Now, my lord, this matter relates to, my lord, some penalty amount that has been, is to be realized from me. Yes, item number 2 in the original side matter. Inside matters. Madam, mentioning upon notice.
ইয়ে আছে আর জুনিয়র আছে না, দুজন জুনিয়র আছে, একজন গেছে ট্রাইব্যুনাল, একজন
Yes, there is an interim order to the extent that, in view of the above, the respondents in Oil Corporation are restrained from realizing the balance penalty amount of so and so for a period of 8 weeks. Now, my lord, 8 weeks is till 27th. Now, my lord, the difficulty I'm facing right now is that it is automatic system. My lord, they may realize the amount. Now, my lord, today in the second half from 2 p.m., my lord, we are under some understanding that there might be some difficulty for your lordships to take up the matter. So I was just beseeching your lordship, my lord, I am mentioning upon notice. I can again come back with a notice to the other side. Lordship would kindly have to take up the matter at 12 noon or 1 p.m. any day time, subject to your lordship's convenience, my lord. Otherwise, my lord, it is an automatic system, my lord. The my balance, the penalty balance amount will they will, my lord, extract from that from me. Yes, they realize from that from.
Anything today for 2 p.m. matter would be not taken up?
No, there is some news going around the High Court, my lord, since yesterday. There might be.
because of program.
Yes, because of Honorable Chief Justice of India becoming to the.
Started at 5.
No,
5. But
our have been restricted to keep our vehicles.
No, you may, because Chief Justice is there.
After one
Chief Justice is there, so that's why the security protocol is there.
Yes, that is that is
the
there.
problem is car parking. All the problem.
security matters not in the matter of this court or court administration.
That is true, but it is relating to all the situation.
Chief Justice and High Court, Supreme Court justices.
Resolution.
This is the issue. So
and also take resolution regarding
the reason
only the Friday since 2 p.m. I am taking these matters.
My lord. So, my lord, the difficulty is that if there is something, then
if there is something,
yes, in the 2 p.m.
I'll 1.
I'll give notice. I'll come back at 1.
1.
Yes.
Okay.
In regard to item
grateful to lord.
162, my lord, or non 162. Both parties they are, my lord, non proceed.
Does not want to proceed further.
162. 2 days list. 162.
Group 6 matters 162.
162. Ujjwal Mondal.
Yes.
Petitioner does not want to proceed further.
You are the body petitioner.
I am
yes, I am the other side.
You are the other side. Give me the instruction. Give me the papers. Cover 162.
যোগাযোগটা ভালো হয়েছে আপনার সাথে, আমি তো অন্য কাজে এসেছিলাম।
Item number 162. Learned advocate on record on behalf of the present petitioner, Mr. Indranath Mitra, submits an instruction that the present petitioner doesn't want to proceed further with this matter. Full stop. The written instruction is kept in the record. Stop.
হয়ে যাক গরিব ছেলে তো বলেছি, আমাদের রেসপন্ডেন্ট আমাদের বিল হবে।
Learned advocate for the respondent is also
Yes, all
considering
responded.
all respondents, considering the submissions and considering the written instructions, the instant writ petition is dismissed as not pressed. And not pressed.
Not this.
Any interim order passed by this court during the pendency of the instant writ petition is hereby also vacated.
It is kept on.
Yes, it is kept.
Slip the
One more intelligence man in regard to 156, kindly make it clear.
Which matter?
156.
You are appearing,
I am appealing for the petition.
who is for the respondent?
So we need
Respondent, whether respondent is here.
kindly make it.
Let me call the matters. You are mentioning 1556.
156.
156.
I am for the petition.
Very well.
My
All the
lord,
matters.
my lord, may I be permitted to mention for extension of an interim order? My lord, it is expiring on 1st of July, my lord. For extension of interim order, Group 8 matter, my lord.
8 matters.
Group 8 matter.
Monday and Wednesday is the day.
Monday it is expiring, my lord. Monday probably the court will be disrupted because of some protest. Something. That is why, my lord. Your
So
lordship.
how can it be? You want to list this matter?
My lord, it is only for extension of interim order. Yes, my lord.
Whether it is listed?
It is in the list. Interim order is expiring on
number?
first. Huh?
Number?
This is 1, 2 serial number.
Serial number?
I will intimate your lordship. Just a minute, my lord.
If it is listed, it can be fixed.
My lord. Just
But if it is not listed, then it would be listed first. Okay.
okay.
Come on Monday or Wednesday.
May I permit to mention one?
Yes.
The matter is for non
Group 6 matters or group 8 matters?
This is the matter if the already division bench has passed an order. The
Group 6 or group 8? Group 8 matters.
possibly group 6
What possibly?
because we have not indicated.
You know the matter. Come on next day, no?
My lord, this item is not running in the list, my lord.
Then it has to be listed first. Okay. Come on Monday. Next. Call the list. First, written the production. My pleasure. What is the application?
Application with regard to a substitution in this
Okay.
matter. Now, for a moment, if your lordship kindly be with the matter in the main matter itself, lordship will find there was a payment schedule.
Yes.
For a moment, if your lordship kindly turn, lordship is checking up my main writ petition or
Yes.
main writ petition. Yes. Lordship will find for a moment, if your lordship kindly turn to page 4 for once.
Yes.
Now, this matter relates to a shift of payment from CDA to IDA in a Food Corporation of India. Now, this is the admitted position and subsequent thereto, the shift has been made. Now, there was an indication in the memo itself that payment is to be ushered from 2015 on regular basis. And as per the area is concerned, that has been kept on hold on the basis of a matter which has been filed where on earth we are unable to understand. Now, if your lordship be with me for one moment on that particular score, now, lordship will find, yes, for page 23. This will make the situation clear.
Yes.
Lordship will find the candidate's name and the indication therein, pay fixed, clause 10. How the pay is to be fixed. Next, the regular pay, as I was indicating your lordship, regular pay from October 2015 onwards may be disbursed. Lordship was found?
Yes.
Next, the very last line, the arrear, if any payable, will be withheld pending decision of the court. What is the court case? Where on earth it has been filed? Nothing, no indication. Now, Lordship, kindly have a look when this is being done. This is 2015. Today we are in 2024. This particular person has already went up to his heavenly abode during this time.
Srimati Kajol Rani Kwal.
Kajol Rani Kwal. That is the reason why we are before your Lordship with the substitution application of his heirs, of our heirs. Now, if at this present moment, this is an admitted claim. What I'm on at this present juncture, Lordship may direct them to pay the arrears subject to the result of any matter. We are unaware. What is the matter? Whether it has been filed here, whether it has been filed in the Privy Council, we are not aware of. This way, the retirement dues of a person is being kept hold of for years, and subsequently he has already went for an heavenly abode.
No, this matter appearing after 4 years.
This appearing, Lordship will find there was a direction from the court. In the meantime, COVID stricken. There was 2.5 years we are halt. Everybody was put on halt for the COVID. And in this COVID, this person went off. Very unfortunate. So what I'm on at the present, Lordship may allow my substitution. And if your Lordship feels, I've already served on them. If your Lordship feels to take it up on next week, I don't mind to. Because this is the admitted position. I am entitled to have the arrears. And they are on the view of a pending, we are unaware of. I don't mind of an area of a pending litigation, which is there. With an undertaking, if your Lordship do allow me, kindly give me my...
Who are the legal heirs?
Who are the legal heirs? Lordship will find from the application. They are the 2 daughters and son. Everybody is there. Ranjan will find from the application, page 2, Ranjan, Sujata and Sutopa.
Page 2.
Page 2.
Yes.
Ranjan, Sujata and Sutopa. They are the legal heirs.
Okay.
Of the fund to be received.
Please take down. Can 1 of 2024. This is an application for substitution of the writ petitioner. Substitution in respect of demise of the writ petitioner, namely Kajol Rani Kwal. Stop. Learned advocate for the petitioner submits that the writ petitioner, namely Kajol Rani Kwal, expired on 20th of May 2021. The present petitioners are the sons and daughters of the present writ petitioner.
My lord, son and daughters. One son,
2 daughters. One son and 2 daughters of the writ petitioner. So he paid for necessary order for substitution. Or the learned advocate peruse the copy of death certificate. It appears that the writ petitioner expired on 28th of May 2021. Present petitioners are the sole surviving legal heirs of the deceased petitioner. Accordingly, the application being Can 1 of 2024 is considered and allowed. Stop. You incorporate their name?
In the main reply, yes.
The legal heirs mentioned in the cause title of the Can 1 of 2024 be incorporated in the cause title of the memo of the cause title of the writ petition. The petitioner is at liberty to incorporate the name of the legal heirs of the deceased petitioner within a fortnight.
But today itself, we are doing it today. Because Lordship, they are without the funds. Lordship kindly appreciate.
Within a week.
Within today itself.
Within a week.
Stop. And the main matter, Lordship, can dispose of.
Next one. Learned advocate for the petition submits that the instant writ petition was preferred against the memo dated 11th of December 2015, wherein the area of the writ petitioner was withheld pending the decision of a court case. Full stop. Learned counsel for the petitioner further submits that the opportunity was given to the respondents authority to file affidavit in opposition, but till today, such affidavit in opposition was not filed. He specifically submits that pending litigation or pending decision of the instant writ petition, the arrear amount may be directed to be withdrawn by the legal heirs of the present writ petition. Full stop. However, heard the learned advocate, it appears that the office reported no affidavit of opposition appeared to have been filed by the respondent. This matter appears after 4 years. Accordingly, I think it necessary to pass a specific direction to the petitioner to serve a notice upon the opposite party.
I've already served with the notice. I am with the notice, in fact.
Very well.
With the notice, in fact.
Serve a notice upon the respondent
Re-notice.
authority, intimating the fact that the matter shall peremptorily appear in the list on 5th of July. 5th of July, next Friday.
Next. But, at the top, because
In a same position.
yes, great.
Can 1 of 2024 disposed of.
Lordship has allowed the application, and I've a ready server would be make us
Yes.
একটু তাড়াতাড়ি সার্ভারটা করে, because we need to communicate.
Yes.
Great. For the petitioner.
But I have instructions to appear on behalf of the respondent number 8.
Lordship, kindly consider. I will not trouble your Lordship much, because on the last occasion your Lordship has considered everything up to accrual of my right, recognized by this honorable court. I will just take 1 minute of your Lordship's precious time just to recapitulate that respectful submission of mine. Lordship, kindly take the trouble to consider 113. This is the honorable court's order, and kindly come to page 115. Only one line. I direct that the concerned respondent to release the salary for the petitioner for the current month within 2 weeks from the date of the receiving of this order, reopening of the offices of the concerned respondents after puja vacation, and to go on paying the same month by month until further orders. This relates to the entire group who are concerned with the family planning welfare of the state government throughout West Bengal, including the petitioner. So my right to receive salary has been recognized by this honorable court, and it has reached its finality. Now, Lordship, kindly consider as your Lordship will appreciate that any organization has got two aspects. One is It's furniture and fixtures and manpower. Combination of both these two items, any center or organization is formed. Why I am submitting before your lordship? Kindly take the trouble to consider 137. This is the government's order, which is under challenge before your lordship. Lordship, kindly consider. The urban family welfare centers of Ultodanga and Dhakuria, named Hindustan such and such, run by such and such scheme, is hereby closed with effect from such and such. Then the very next line, assets and liability are to be handed over to the District Family Welfare Bureau. Nothing to do with the employment or salary. Lordship, kindly correlate with 115. Government knows with their eyes open that this responsibility is there. So whatever materials to continue with the project, I have given. You hand over this. And on the last occasion, I have shown before your lordship that in the public interest, the place of sitting is being changed from one to another. Lordship, kindly take the trouble.
No, the issue is that you have challenged the memo of 27th of November 2019.
Yes, Lordship.
Regarding closing of the
Prayer
Urban
H.
Family Welfare Center.
Lordship, kindly take the trouble to pay, prayer H.
And 110 is the memorandum of 71.
Yes.
Of 71.
Yes.
It says that the employees has to be absorbed.
Absolutely. I bow down to your lordship. Nowhere in the writ, nor in the prayer, we have said, I am required to be observed. No. Lordship, kindly take the trouble to consider page 44. Page 44. My prayer. H. An order to issue direction, directing the respondents, state respondent not to disturb such and such, and release the salary grant. Because Honorable High Court never said in the order 113 that I am required to be observed. It was never the case of the petitioners, because we know we are under a scheme. Our place of sitting is XYZ. Fund is coming from central government. State government is distributing the same. State government is the nodal body. 71 speaks about absorption. I am not placing my prayer before your lordship to that higher level, because if absorptions come, then the Honorable Supreme Court's direction, various factors will come. I am not on that. I am before your lordship on a very plain and simple prayer.
What is
continuation
of service?
Salary.
Continuous salary without service?
No. Lordship, kindly consider. Service means you are required to change my place of sitting from A to B. That you have done earliest stages and in the public interest.
No, after the memo of 27th of November 2019, impugned memo, you have not given any service.
Lordship, kindly consider, I am coming to the exception and the report filed by the government. Lordship, kindly consider. That November notice your lordship has seen. Lordship, kindly consider two dates. The report has been affirmed by the state government on 24th January 2000. Nowhere it has been stated 24th January 2020. Lordship, kindly consider the report submitted by the state government, which has been affirmed on 24th January 2020.
Report of voice. Evidence. नहीं.
Achhi. Apna copy. May I hand up a copy, Lordship, which has been served by to us?
No report is there. We just.
Lordship, this is the report which has been given to us. আমরা কপি দিয়ে দিচ্ছি আমাদের আপনার তো ইয়ে করা আছে আপনাদের দিয়ে কোনো অসুবিধা নেই may I submit the report which has been given to us, our copy? This is the government's letter. With government's letter, it has been served to us. With the government's letter.
Have you filed the report?
Lordship, kindly keep this thing.
I shall hear you, no issue. I shall hear you.
Lordship, kindly consider.
Just wait.
Lordship, may I hand up the exception to the report?
Served.
We have served others.
But report was not placed in the report.
Lordship,
No order is there regarding the.
Lordship, thereafter no hearing has been taken. COVID and all these things. Lordship, kindly consider this is the document. This has been served to us and we have filed our exception also. Lordship, kindly take this up as part of the proceedings, Lordship. I will not trouble your Lordship with much with the report. Page 2, Lordship, kindly take the trouble.
Have you got the copy, the report? There, proceed.
Lordship, kindly consider page 2. The date of affirmation is 24th January 2020.
Yes.
Lordship, before I take your Lordship much deep into the report, Lordship, kindly take the trouble to my exception. Page 7. Annexure P19. This is a letter dated 20th January 2020. Government is writing us. No action has been taken. Then 27/11/2019, in my respectful submission before your Lordship, no effect is there. No effect is there. Which is bothering your Lordship, what I have in my respectful submission is the point, certainly, after 2019 27th November 2019, what is the effect? Government written this letter to the learned advocate of the petitioner. Name of the learned advocate of the petitioner is their lordship. Second recipient. Government is writing no action. That means 27th November 2019, no effect has been given. If I am permitted to submit my respectful submission in this way. So I am in a limbo. I do not know why I am not being paid in view of the order of the Honorable High Court. Are they, may I put a question to myself, are they trying to bypass the Honorable Court's orders without challenging the same? Or in the, now your lordship kindly consider the report. Consider the report. Nowhere, my learned, the state government has said the order is no more in existence because of the decision of higher forum. No plea has been taken. First. Secondly, it has never said that I don't have any right to salary, my livelihood. I appreciate what is bothering your lordship, that my right to life and enjoy salary, I have to earn it. It is not like gratuity. It will be doled out. But if I am refused to, because after 2020 later, 20th January 2020 later, everything is clear. 27th November 19 later is no more in existence because they have not taken any action. No action will be taken. Then obviously it was the bounden duty of the government to place me in different centers. Because money is coming from the central government, you are the nodal body, Honorable Court's order. These three factual aspects, if your lordship kindly make a straight line, it will show my right to enjoy salary has been curtailed by dint of the inaction on the part of the state government. Not a single time I am making any submission before your lordship for absorption. Lordship, kindly take the trouble, page 3 of the report.
No, why the letter, page number 7?
Which one, lordship? That is the exception, lordship. I am on report.
No, I understand. Why the letter has forwarded to you? What is your letter to the secretary? In response, this letter was forwarded.
Just a minute.
What is your letter?
Number milega jo? Lordship, kindly take the trouble. 133. 133 is my letter. Writ petition. Learned advocate of the petitioner wrote the letter to the government. This is the letter, lordship, 133. This is the letter. Lordship, I have mentioned 135. Lordship, kindly take the trouble. 135, item number 7. I have mentioned 135, item number 7. It is pertinent to mention, para 7, Lordship, kindly take the trouble. It is pertinent to mention that here that 2 writ petitions being WP number such and such as pending before the Honorable High Court regarding the service conditions of the said employees along with other employees of the different voluntary organizations. Several orders have been passed, and pursuant to the orders passed by the Honorable High Court at Calcutta, the employees of the said two units are getting salaries from the government grant. So,
Where is the order?
which one, Lordship? 113?
No, 135 you have just mentioned?
Item number 7, Lordship.
Yes. Where is the order?
It is pertinent to mention, as your Lordship.
Yes.
Writ petition.
Where are the order of those two writ petitions?
Lordship, kindly take the trouble to 113. 113, Lordship, kindly take the trouble. 113.
Yes.
Number WP 9368, W of 2003, WP 2642 of 1999. These two writ petitions have been mentioned in 135.
Okay.
Lordship, kindly take the trouble.
113.
Yes, 113, the numbers of the writ petition, and 135, the numbers of the writ petitions are same.
Yes.
So my right to receive salary is still in existence. Once the letter of the learned advocate of the petitioner is being received by the government has thought that they have committed wrong. That's why a reply has been given on 28th January 2020. The exception, page 7, Lordship.
Okay.
And Lordship, kindly consider Lordship, kindly take the trouble to consider. I make it absolutely clear, Lordship, my clients do not want to enjoy a single farthing of the public exchequer by not doing the work. They have made representation before the government. Lordship, kindly take the trouble. 132. 132. Before the learned advocates writes the letter to the government, the writ petitioners have, Lordship, 132.
Yes.
Much prior to the learned advocate's letter, I have written, last but 2 paragraphs. We would humbly request not to allow closure and of those centers so that we can continue to serve the local patients and the other acceptors. However, in the event of closure of these 2 centers, we would humbly request you to induct the employees in these 2 centers in similar organization, as most of us are the sole breadwinners. So I have offered myself for relocation. It has been done earlier in the interest of public service. Lordship, kindly take the trouble. Page 102. Government is writing, Lordship, kindly consider 102. Lordship, kindly take the trouble. 102. Government is ordering. Last line. This move is in the interest of public interest. And it was the addressee is Dr. Rama Chakraborty, Lordship, the first petitioner before your Lordship.
Prior to closure of this unit.
Yes. So relocation is always there.
Yes. Relocation is
always there.
Avenue is always there.
Is always there. So that's why what is bothering your Lordship, the concept of absorption and my right to salary. It cannot be, in my respectful submission, cannot be correlated with. I am not praying for any absorption. Because age factor comes into play. Because if the government service is there, age factor comes into play. That's why when the government issued the ROPA, debarring us, after 60 years, we will not be entitled to any salary. Lordship, one month, 111, Lordship, kindly take the trouble.
At the last of
last 60 years, thereafter I will not get. Honorable Court has said no, right to continue the salary will be there. So our salary is covered under ROPA. ROPA applies to the government employees, where the government has said after 60 years, these employees will not get. Now we have come before your Lordship, this Honorable Court. In this order, by this order, 113, government has said, this Honorable Court has said, you are required to continue with the payment. Honorable Court is well aware of the fact regarding absorption and regularization. The conditions of the Honorable Supreme Court. We are nowhere stating before your Lordship. We are not making any respectful submission before your Lordship regarding absorption. My right to salary, which is bothering your Lordship, that without work I will be enjoying salary. That is bothering. Lordship, it is a very fundamental thing of service jurisprudence. Without work, you cannot. Now, Lordship, that principle will not apply so far as this case is concerned. Because when government has given this ROPA, under ROPA, this thing has been given. Honorable Court has said, has been pleased to say, direct the government to continue with the salary. The Honorable Court, this memorandum was placed, and that's why the Honorable Court is of the view that the right to get salary or the quantum, whatever is there, having correlation with the age of superannuation as 60, cannot be equated.
Show me the ROPA order, 111.
111. And I bow down to your Lordship that your Lordship has been pleased to memorize the last line even, so far as the order is concerned. 111.
Yes.
In these circumstances, Lordship, kindly consider, under the second para, the undersigned is directed to say that it has been found some of the employees of approved NGOs have crossed the age limit of 60. Lordship, pausing for a moment. It is fundamental, after crossing 60, no service can be regularized or absorbed. But yet, they are in service with the respective pay scale under ROPA 19. So I am being protected under ROPA 98. Some of the employees even entered in approved NGO service after the cross of age 60. So it is not that I have crossed. Even somebody has been inducted after 60. So concept of absorption does not apply. Under the regular pay scale, time to time with the inadvertent approval of the Director of Health Service. In these circumstances, Family Welfare Branch, Department of Health and Family Welfare, Government of West Bengal has decided not to pay salary. Under West Bengal ROPA rules 1998 or any other subsequent revision of pay and allowance rules will be granted to the employees who cross 60 years with effect from 1/1/2012. These orders supersedes
all other orders.
It has been stated. Lordship, kindly consider page 113 with the start. Lordship, kindly consider 113. Last paragraph. The immediate occasion for filing the present application is a memorandum issued by the respondent number 4. Has the Lordship got it? Lordship, 113.
Yes.
Last para. The immediate occasion of filing the present application is memorandum issued by the respondent number 4, by which it has been notified that the respondent number 1 had decided that no salary under West Bengal Service ROPA rules 1998 or any other subsequent revision of pay and allowances rule would be granted to the employees who had crossed the age of 60 years with effect from April 1, 2012. This is the line in the memorandum. Then next page, Lordship, kindly take the trouble. First, second, third para. Mr. Dotto submits that. Lordship, kindly consider from the first line. By the present application, petitioners are praying for an order quashing the said memo pending the disposal of the writ application. Has the Lordship got it? I have heard the learned advocates for the petitioners as well as the state respondents. The state respondents only prayed for a direction to file affidavit in the said application. Mr. Dotto submits that even if the petitioners have crossed the age of 60, they are, by virtue of a communication dated June 11, 2008, made by the respondent number 6, are still entitled to work. The petitioners insist that as per the said communication, there is no age limit fixed by the government for either appointment or retirement of the staff of urban welfare centers attached to different NGOs. Mr. Dotto submits that in view of the court order of the court, as well as in view of the very specific communication made by a competent authority on behalf of the state respondents, the petitioners are entitled to work beyond 60. So what is bothering your lordship? What is passing through your lordship's mind? The age factor. My respectful submission is
No, my just clear.
Lordship, kindly consider the last two lines.
I understand. This memo has been challenged in this matter regarding the ROPA.
Please, Lordship.
That you are not directed. State is not giving any pay beyond the 60 years.
Yes.
But the fact suggests that there are some NGOs where the person are employed beyond 60 years and they are working.
Yes.
This is on view of that fact, the order was passed, you cannot divert them the salary.
Lordship, prior to that, Lordship, only I beseech your Lordship 2 lines of 114.
Yes.
The entire order has been stayed. So whether I crossed 60 years in service or my induction in service, 2 categories. I am in service, cross 60 years.
Yes.
Some persons have been inducted in service after 60 years. Both are treated at par. And that's why the order has been stayed. Lordship, kindly consider. There shall be an interim order in terms of prayer B of the said application for a period of 4 weeks after reopening of the court after puja vacation, with a liberty to pray extension of the said notice to the respondents. Mr. Dotto makes a grievance that they are not getting their salaries from April 2012. In that situation, it has been done.
Yes.
And Lordship, I am continuing. They filed appeal. The appeal dismissed. Appeal dismissed. Lordship, kindly consider the order has been confirmed. Lordship, kindly take that up. Lordship, kindly consider. Application for recalling. Against this order, the state filed an application for recalling. And that was not entertained by the Honorable Court. Against that, they went in appeal. Lordship, kindly consider. And the Honorable Division Bench was kind enough to definitely first paragraph. First paragraph. At a day's list, liberty. Then order to be 18 doses. না এখানে কন্ডোনেশন অফ ডিলেটাকে ইয়ে করলো That's right. Lordship, can you take the trouble to consider? Acted. That has not been interfered. Lordship, can you take the trouble? After this order, the state government is continuing with the payment. Lordship, kindly consider 120 of the writ application. Lordship, kindly consider. Lordship, kindly consider 120. On the last occasion, I have shown before the Lordship the remarks 18, item number 18 within the square. Has the Lordship got it? 18. Above 80 rupees such and such. Above 60 rupees such and such. Dr. R. Chakraborty, the petitioner before your Lordship, the first petitioner. What is the date of sanction of the money? 13th August 2019. So till August I got the money. And below 60 is also there, Lordship. Ajay, Lordship, kindly consider two categories I have submitted before your Lordship. One is below 60, another is above 60. In 18, your Lordship, you will find below 60 also. Lordship, kindly consider just above that.
Yes.
Are above. The writ petitioner before your Lordship, some of them are below 60, some of them are above. So we are covered. So government knows. Yes. In acceptance of the Honorable Court's order, they are continuously paying us. And may I put a question to myself? Can it be said that writ is not maintainable, which my learned friend has just now said? Because already two writ applications is pending where order has been given in protecting my right to receive emoluments. And everybody is getting. Why I should be discriminated? Because of the fact my seat has been taken away, nothing else. And the decision to take away my seat has also been not given effect to. Government, by a letter dated 20th January 2020, has informed my learned advocate of the petitioner that no action has been taken. So, 27/11/2019 order goes. My entitlement is protected by this Honorable Court. Government is continuing with the payment.
Continue with the payment by virtue of order dated 18th of October.
Yes.
18th of October 2012.
Yes. And I have also got that 120, that is of 2019.
Yes.
19.
So after the closure,
Closure has not been taken effect to my respectful submission. What 20?
After the closure, what right you have?
Lordship, kindly consider my right has been accrued because of 20th January 2020. My representation, government has said I am not taking any action.
As the matter is sub judice.
Yes, that's true. Whatever may be the reason. Now, Lordship, kindly consider after, let us say, 12 and 13 years, the court can, state cannot arise from a slumber and say that writ is not maintainable. It is not such a technical way in the final hearing when my right has been accrued. It cannot be said that writ is not maintainable.
No, after 27th of November 2019,
yes,
the date of closure.
Yes.
What right you have?
No, closure is there because of 2020 order.
What are the instances that you have there is no closure? Whether the welfare centers are running?
Lordship, kindly consider my service, whether it is running or not, my service can be utilized by the government in other centers because other centers are open.
Your service is purely temporary.
Which one?
Your service?
My right to receive salary is protected.
Without service, you can you receive the salary?
I have offered myself to give salary. If the service taker in a wrong action, if I am permitted to submit before your lordship.
Yes, you can challenge the wrong action, no issue. You can challenge.
Then my right accrued.
Why you should write without any service? How can you?
No, my service. May I put a question to myself? If I accept the submission of the state government that my service is correlated with the NGO, I accept. Let us say, then as per service jurisprudence, my service cannot be regulated or supervised by state government. Cannot. My transfer cannot be done by state government. Cannot. So the supervision and control is the main thing. Lordship, let us forget.
Supervision and control by the NGOs?
No. That's why, Lordship, kindly consider 120 of the writ application. Kindly come. Sorry, 102. Kindly come.
Yes.
Who has issued the order? Not NGO. Government has issued the order in the public interest. Let us see. Dr. Rama Chakraborty, the writ petitioner before your lordship, attached to Birla Social Welfare Scheme. That's why I am submitting before your lordship. That is my place of sit. It has not been said I have been employed by Birla because government cannot direct. A person cannot have two employers at a time.
Then where is your service condition?
Which one? That is governed by the government. ROPA?
Who engaged you?
At the approval of the government. NGO has engaged. But the supervision and control.
Yes, NGO has given the grant in aid.
Grant in aid. NGO
your service has been taken by the government sometimes.
No, not sometimes, every time. All the time. All the time. Lordship, kindly consider the selection. Page 95, kindly consider the selection. Lordship, kindly come to 94 first. Kindly come to 94 first. My everything from only this is a paper arrangement. NGO is put, it directed to give the appointment letter, but everything, my selection, everything, all directions are given by government. Lordship, kindly consider page 94. Appointment of such and such for union, for units, Dhakuria unit. Government is directing. With reference to your memo number such and such, your organization, the following instructions should be strictly followed. Had it been a case that I am an employee of NGO, government has got nothing to do, then Lordship kindly consider selection committee. Next next page is 95. Selection committee, government has said, I am an employee of NGO. Government has got no business to construe to form the selection committee. Government has got no business. 96. Government is giving the appointment of storekeeper. Then 97. Lordship kindly consider 98. Is a very vital thing, the in-depth supervision and control. Had it been a case NGO has got authority to appoint dezoning government, then government would not have issued this letter that without my approval, how can you do this thing? On scrutiny, Lordship kindly consider. On scrutiny, it appears from the broadsheet of the interview that Sri Sachan Sach, serial number 1, has been placed first in the panel, which is required to be approved from such and such. This is the government. Social welfare organization. State family welfare organization. But without such approval, he has been allowed to join such and such. This is the government body. On such and such, which is not irregular. Further, you have claim aid, claim his pay, etc. In the maintenance of the grant. This should be clarified in details. Otherwise, his pay will be deducted from your bill. So, entire. Lordship kindly consider selection committee appointment. A person has been appointed without the approval of the state welfare organization. He has been castigated. If I am an employee of NGO, in my respectful submission, government will not exercise this. Will not exercise this. 103, Lordship kindly consider. And 103. Lordship kindly consider. Lordship kindly consider 103. Last 1, 2, 3, 4, 5, 6, 7, 8 lines. A duplicate service book. Has the Lordship got it? The last portion. Yes. Towards bottom. A duplicate service book duly attested by the authority of the respective voluntary organization would be the custodian of the service book, which are to be kept ready for inspection by the authorized person of both central and state authorities, authorized persons, audit agency, at the time of their visit on the visit or on requirement. Lordship, pausing for a moment. May I put a question to myself? 111, ROPA.
Yes.
98, I was paid. Had it been a case, I don't have any service rule, or my service conditions are not governed as per the government's guideline or by the government, ROPA shall not apply. ROPA shall not apply. The 111, page number 111 memorandum creates my right. It cannot be brushed aside by making a respectful submission, only one line respectful submission before your Lordship, that they have been engaged by NGO. so REIT is not maintainable. No. The 99 REIT, 2000 REIT, all the employees, all the connected REIT petitioners are the employees of different place of sit. It may be by NGO, it may be by Ramkrishna Mission, whatever. It is written that HON'BLE is there. So, Lordship, kindly consider my selection, appointment, what was bothering your Lordship, service book, ROPA, Honorable Court's order, Honorable Division Bench order, then relocation in the public interest. Your Lordship, they may think that closure of NGO or my place of sit will disown the liability. I can disown the liability, which is public in nature. That cannot be done. And Lordship, kindly consider, it cannot be disowned. And closure means government also knows, not the human resources, because they will be relocated everywhere. And grant is coming from central government. And state government is the nodal authority to disburse. So there cannot be any stand of paucity of fund. First, that stand has not been taken. Has not been taken by the government. Then Lordship, kindly take the trouble. Lordship, kindly consider the notification on which my learned friend that state government has tried to bank on of 1982, page 30 of the of the report, page 50 of the page 13 of the report, page 13 of the report. All the persons are required to be attached with the hospitals because it is a public service. Lordship, kindly consider. Government is issuing this order. Secretary. In continuance, has the Lordship got it? In continuance of the government order. 82. 82, that's all. That's why they have relied on this. In continuation of the government order dated such and such, and in reference to your letter dated such and such, the undersigned is directed by the order of the governor. Honorable Governor is giving to say that the cover or whatever has been pleased to the governor, maybe. The governor has been pleased to accord sanction to the opening of type 3 urban family welfare center. So with the governor's approval, government is doing this thing. Lordship, kindly consider. Next page, I will not bother much with this. Next page, Lordship, kindly consider. Since I am doing public service, approval of the Honorable Governor is required. Now, Lordship, kindly consider.
This is in respect of other areas.
Yes, Lordship, kindly consider. They relied on this. They have relied on this to substantiate their clause when there is a closure. No granting aid will be there. Lordship, kindly take the trouble. 51. Yes. Next page, 14.
Yes.
And my respectful submission before your Lordship, This clause doesn't apply to me. 6, item 6, Lordship, has the Lordship got it?
Yes.
Next page. The grant in aid in this respect will be released, has the Lordship got it? Will be released on express condition that in case of the institution decides to discontinue the family welfare program, or the government decide to discontinue the sanction of grant for the unsatisfactory performance or otherwise, the responsibility of maintenance of staff sanctioned for the purpose of running family welfare center shall devolve on the institution themselves, and no staff shall be absorbed in the government under any circumstances. Pausing for a moment. We are not asking for absorption. This circular was there when the Honorable Court in 2012, the order was pleased to pass the order. Now we are not coming under the first clause, that closure. Honorable, the governor has, the secretary has already informed, no action. Secondly, there is no allegation that our performance, the center of the performance of our center is unsatisfactory. Now, thirdly, I do not want to be absorbed. There is no prayer regarding absorption. Kindly consider, Lordship, 107 of the writ petition. Lordship, kindly consider, this is of 1982, which the state government is relying on, and I am showing of 1994, which government is saying. It has been informed by Government of India. Has the Lordship got it? Because fund is given by Government of India to monitor the performance of all PP units and UFW centers attached to the government, local bodies, COL, volunteer, it must be VOL, organization regularly to boost up their performance. Those units which will fail to achieve 85% of the target will not be entitled for the financial assistance. This allegation is not with me. GOI has also suggested to shift such low performing units to the better performing centers. Under these circumstances, you are requested to opine about the type of low performing units within your jurisdiction with the detailed report at an early date, together with the proposal of shifting of the center to elsewhere. Lordship, kindly take the trouble. Another communication of 1996, that is page 108. It is from Joint Secretary. The undersigned is directed to say that, may I please be for the performance of UFWCs run by different NGOs appeared to be far below the target level prescribed by the Government of India. The Government of India, in their latest circular, directed to withdraw the centers whose performance are below 85% of the target and distribute the employees. Lordship, kindly see, distribute the employees of those centers to better performing units. So my service will not be discontinued. Moreover, serious audit queries for non-release of grants, this is, Lordship, a different aspect. So what I respectfully submit before your Lordship, I have offered myself to be shifted to anywhere. And the order which has been confirmed by the Honorable Division Bench, the highest forum of the state judiciary, cannot be bypassed by the action or inaction, let us say inaction on the part of the state government. and contradictory stand, your lordship kindly see. They are taking the plea of a circular of 1984, of 1982 or 83, which speaks about absorption. I have never said about absorption. Honorable Court, what was bothering your lordship regarding my service book? Service book I have shown. ROPA 98 I have enjoyed. Considering this, Honorable Court has said that my right to receive salary continues. Government knew this thing. That's why on 27th November 2019, just told the center by place of sit to hand over the assets and liability. Nothing to do with the employees, because government knows they are required to be relocated because public interest is involved.
Yes.
Public interest is involved. So, just making a respectful submission before your lordship by the respondents that REIT is not maintainable will not change the character of the earlier REIT application through which my right has been accrued. This is utter discrimination. It is like that your hairs are gray, that's why I am not liking you, because I like the black hairs. Only Dhakuria and those place of the persons working there, they are the doctors. And government and the court has said 60, absolutely 60 and beyond 60, never discriminated. Now, when this honorable court, by virtue of the order, has guaranteed my right to receive salary, may I put a question to myself, lordship? Can the government discontinue with the same? NGO discontinuation is a different aspect than that of my right to receive salary. Grant provided by the central government, which has reached its finality by virtue of the Honorable Division Bench order, which cannot be curtailed, lordship. This cannot be curtailed. My service has not been touched. My service has not been touched. If I am permitted to submit before your lordship, since my selection committee, approval, payment, all are done by the government, issuance of appointment letter just to disown the responsibility, state's responsibility, is a camouflage, is a sham, this is a paperwork. That they are not, then the government will not be saddled with the cost of pension and other benefits. I did not want the other benefits or pension. I did not. I never. Only as per the court's order, my right to receive salary. Your lordship, what is bothering, what I have little understood your lordship mind, without work, how can it? I have not, it is not that.
I have just heard. The issue is that where you have been appointed. You have been appointed as a LMO in a center.
Yes.
This is the appointment system, appointment procedure of the government.
Absolutely.
And they have some
territory
where you have to work.
Yes.
I understand that your work has been obtained by separate centers also.
Yes.
Several locations.
Yes.
But whether that entitle you right to receive the salary without work.
Lordship, kindly consider. That's why
I understand your submission and the argument that the action taken by the government regarding the closure of the units may be, according to your submission, may be illegal. But whether terming as illegal of the order can allow you to receive the salary without work.
May I put a question to myself? When my service has been terminated by way of disciplinary action,
service has not been terminated by the government.
I bow down to your lordship.
I understand your argument. I understand your argument.
Nor by the center.
No, your service has been appointed by the government to work for a certain purpose.
Yes. That purpose has not been evolved or has not been evaporated.
So
It is not the stand of the government.
Whether that can bound the government to allow you to continue without salary, without any work.
Lordship, let us forget about for a second. Let us forget for a second.
I hear you.
Let us forget for a second about the case. My service has been terminated. I am working in a bank or in a government or with any authority covered under Article 12. My service has been terminated. Your Lordship, since your Lordship has opened your Lordship's mind for my better understanding,
Yes.
For my better understanding, don't take me amiss, Lordship. The order of the government is illegal, let us say, for the sake of argument, since your Lordship has given some indication.
Yes.
For my better understanding, not with the
Yes,
case.
yes, yes.
If it is illegal, my restoration of service is an automatic one.
Yes, that can be.
Is an automatic one. If my service is an automatic one, the place of employment may not be in existence when I was there. My service may be relocated to any other place. Suppose I am a bank employee. For any XYZ, my service has been terminated. Branch of that bank has been abolished. Your Lordship's finding is my termination is illegal. I am entitled to back wages with reinstatement. If I have not crossed the age of superannuation, then automatic reinstatement will be there. And the concept of reinstatement postulates at the place of work wherefrom I have terminated. That is the basic thing of industrial law as well as service law.
Yes.
If that branch is closed, is it not the duty of the bank or any authority under Article 12 to place me in other place of work, relocate me at the other place where my service can be utilized? It is always there. There are a number of judgments. I do not want to bother your Lordship with any of the judgments because in my case, none of the judgments are required to be cited. With deepest humility, I can submit before your Lordship. None of the judgments are required to be cited because facts are admitted. My relocation of duty before closure was always done by the government in the public interest. So that's why I have used the word camouflage. Issuance of appointment letter by NGO and banking on that, when the right to receive my salary is protected by this honorable court, using that letter to disown the liability,
yes,
is a camouflage. And your Lordship kindly consider, in the report, the state government has not said a single word. It has not wasted a single word. That performance was wrong. I was incapable to work. And there is any law and order issue or integrity issue is there. Nothing is there. And the circular which they have relied on, that relates to absorption. I never paid for absorption. This is of 1984 or 82. This circular was in existence when 2012 was there. And in case of any wrong performance or below performance, Government of India is saying you transfer the employees to other. And my non-performance has never been an issue. So when the money provider, central government is the money provider, he is directing the nodal authority to work in this fashion, can the nodal authority, may I put a question to myself, Lordship, do otherwise? It is the human being. Organization is concerned with the human being, not with the assets and liability.
Yes.
Everywhere, your Lordship's direction, everywhere was there in protecting the human right. Right to life includes right to salary. It is not that I, of my own, did not join the service. It is not the case of my learned defense client that I have refused the employment. It is not the case of my learned friend client that I have prayed for absorption. It is not the case of my learned defense client that I have prayed for regularization. It is not the case of my learned defense client that I have not been paid ROPA 90. It is also not the case of my learned defense client that 111 circular has been revived by them by issuing any subsequent circular. If these things are with the petitioners, the right to receive salary exists. It is restored. I have offered myself. My learned advocate has offered. My clients are ready to go to any other place. It is not the case of my learned defense client that this fund, coming of this fund from the government has been stopped. It is not the case of my learned defense client that they are not providing family welfare service in the interest of the public. And Lordship, kindly consider, it is the specific pleading of the petitioner before your Lordship. Para 54, para 44, Lordship, kindly take the trouble. Lordship, kindly take the trouble, page 32. Para 44, Lordship. Yes. Your petitioner states that as per the documents annexed with the writ petition, the writ petitioner ought to have been accommodated. 1994 circular of the government, 1996 circular of the government. In other centers, as has been done in the past by the state respondent authorities, and without transferring the service of the writ petitioner and any other voluntary organization and stroke or local bodies and stroke or family welfare centers, the state respondent could not have. Now that is Lordship's mind. We have got that even if that order is there, it may be termed as illegal or whatever may be. I am not going into that far, Lordship. Yes. Lordship, kindly consider one thing. I am making a via media submission to find a via media. I am making a submission via media so that state should not be unnecessarily bothered and our right may also be protected. My offer, your Lordship has seen, 2019, I have offered myself to be transferred to any other place, to be reallocated, to be reallocated to any other place. Government's 2019 order, in my respectful submission, is not in existence. Matter is pending before your Lordship. Normally, a question will certainly crop up when you have not, rightly or wrongly, writ petition is pending. It has not reached its finality. And when it is bothering your Lordship, because with your Lordship's judicial consent is there, because the Honorable Supreme Court's order, without work, how can you earn the salary? I bow down to your Lordship. Since the writ application is pending, let the state government relocate us from July onwards, pay us the salary, pay us the salary as per the honorable court's order, and my entitlement to receive salary will be decided at the final adjudication for 2019 to 2024. This via media, I can request my learned senior to have a word with his client. I can make this submission before your lordship, because my right to livelihood is protected, lordship. That cannot be waived. Let our services be relocated, lordship. Let the writ application be kept pending. I don't have any difficulty. Let the government take a decision and come before your lordship with a specific time frame. Your lordship kindly fix the matter for final adjudication as part heard in the month of August. I don't have any difficulty. Let my service be relocated by the government. Let them take time for 60 days to relocate myself. And from July, I may be given an opportunity, because my clients are not interested to get money without any work. They are all self-respected person, and they want to serve the society. They are the doctors and connected with other paramedical functions. They do not want to enjoy money without serving the people. Although they are in utter distress for last 4 years, but I may, if your lordship so pleases, I will certainly request the petitioner to bear with the honorable court to take a final decision regarding their penury and all these things, and fixing the date in the month of August. Let us join in the month of July, from July, and let the payment be started.
Yes, for the state.
And they have not given any
of the proposal. No, I am not going to the merit. In respect of the proposal, if you want some instruction, you can take it, or if you have instruction to go with this matter, I will hear it. What is your submission? Then come next week, take the instruction. Have you understand the instruction? Or 15 days time, or any specific order is required?
Let there be specific order, lordship. Because I cannot be rest in limbo just like last 5 years. I do not want to be rest in limbo, because it's the plight of my client.
Yes. You understand what this court need?
Any other
Location.
They are not.
I understand. Very good, very good. Please take down.
Age of 60 is a cause that the honorable court's order is there, whether I'm in 60 or without.
Petitioner challenge the
Closure.
order of 17/11/2019, where they 2 units were blocked. But salary regarding salary, that is not paid in the state.
Prayer H.
Goes down, that is main challenge. Other there are equal restitution as I found from the petition. Seaport replication payment. So lordship clear out the matter analogously.
Analogously. No, I have only group 6 matters for a specific time. I think it would be 2019 to 2021, something like that. 2018 to 2021, I have the determination all.
You are asking for pension and gratuity.
That is the issue. In the earlier writ application, there was the issue was what I am told is gratuity and pension. Gratuity and pension and retirement benefit, other retirement. Well, let it be decided. Yes. Nothing to do with this.
No. May I heard I was appearing for the respond number 8. Although I don't have much to say before Lordship, Malad, the only
You are the respondent number 8.
8.
Who are you?
The institution.
The institution.
The institution, which has been closed by the government's order. Now, Malad, I just, whatever I've little understood from my learned seniors' submissions, Malad, the main point on which the writ petitioners are banking on is the order at page 113, the writ petitions of 2003 and 1999. The interim order, which was granted by this honorable court to directing the respondent authorities to pay the salary for those times to those writ petitioners. We do not have the information who were the writ petitioners here, Malad. I do not know. But Malad, ultimate fate of these writ petitions, if my learned friends are banking on this order, saying that since this honorable court had directed payment of salary and the same had continued for a certain time and the salaries were paid till. So my learned friends assurance that by saying that this writ petitions, the order passed by this honorable court has in fact kept the entire matter pending. This was the reason why the government in their reply to the writ petitioners, learned advocate, had stated that since those writ petitions are pending, since that is sub judice, that is why no action is taken. It is not saying that nothing has been closed, nothing has been done as per the order dated November 2019. It's not saying that. It's saying the government is informing the learned advocate for the writ petitioners that since 2 writ petitions are pending before the Honorable High Court at Calcutta, specifically numbering these writ petitions, the numbers that are being shown at.
I am not disturbing my learner friend. Whether I want to understand one thing, whether my learner friend is arguing for the state or not, because it cannot be the submissions of private parties.
Why cannot be? I am the affected respondent here.
Nothing to do. He is the
No. Whether
money is not the.
I want the answer from the state. Whether you are coming with the instruction or you want to proceed with this, take instruction in respect of the allocation of the petitioners.
This is merely an interim order, Malad. This is merely an interim order.
No, I understand. I understand your submission. That is not the issue. I just want to answer from the state. So you are not ready today.
This proposal had come to us.
Let there be specific order. Let us see.
The proposal was given.
Again, you are going to the merit. Then I shall hear the merit.
But she
just I want to ask you whether you are ready to do the merit or you want the instruction. You will take the instruction regarding the claim raised by the learned advocate for the petitioner. What is the stand of the state government? Very well. Please take down. And you take the report, earlier report. No. This is not the report. You have not filed any report to the court. I am taking the report of the copy of the report from the writ petitioner. That is not the issue of the court to look after. Where is your file? Where is your report? Please take down. During the course of argument, It appears that the instant writ petitioner may be decided at its outset if a specific report and reply to the reply from the respondent authority concerned be reached to this court. Accordingly, the state is directed to file a specific report in the form of affidavit containing the fact, the possibility of relocation of the present petitioner to any center, to any, which center? Is there any center running?
Yes, all. Several.
Several centers are running. To relocation of the present petitioner to any family planning units
In Calcutta.
in Calcutta under the same scheme.
And nearby districts. The
Of Calcutta or nearby districts,
yes,
running in under the same scheme. Full stop. কি বললাম বল? প্রথম থেকে। ওই দেখ। Fact regarding possibility. In Calcutta or any Calcutta and surrounding districts. Surrounding districts. Under the same scheme. Under the same family welfare scheme. That is directed to submit the report by 2 weeks from that. Let the matter appear in the list on 19th of July for further consideration.
Instead of 19th, anything, any subject.
19 is the Friday. I will only take these matters on Friday.
Can it be subject to lordship on 26th?
26th, it may be 26th.
Yes, yes, sir.
26th.
Government will also get some more time.
Yes.
Only one direction subject to lordship kind approval. Petitioner is also has the liberty to communicate this order to the government.
Okay. Full stop. 26. Petitioner is at liberty to communicate the order to the state authority.
Lordship part had the same.
Yes.
Part had this.
Yes. For further consideration.
As part had lordship.
Want this part heard?
Yes, yes, Lord.
Let's be. I do not meditate in part heard any matter.
Lordship, this is part heard. Lordship, kindly consider your lordship's list. Last order is part heard. Lordship, kindly.
If the last order is part heard, then it would be part heard.
Lordship, kindly consider it is part heard and also.
Okay.
And everything your lordship has kind enough to accept. Only last one as top lordship. Lordship, only last one. Everything your lordship has kind enough to accept. The last one.
No, it will appear on top. No issue. Part heard will always appear on top.
I deplore this.
Part heard matter will always appear on top.
Yes. And deplore this.
Yes, sir.
So the crux of the dispute before your lordship is this. There is stark discrimination in the matter of fixation of pension
between some of the judges of the Honorable High Court and one of the judges of the Honorable High Court. There is stark discrimination about fixation and the amount also. Lordship, kindly take up my writ petition. A small one, facts are admitted. Facts are not disputed.
Who is appearing for the authority concerned?
My Lord, both for the state and the Union of India, they were appearing. They have given their reports or also. These are our replies to that. I've served them. But unfortunately, Tudunani is here. In fact, I didn't want to steal a march over them in their absence. Union of India's presence is required.
Yes. The report in the form of affidavit.
State is not in fact disputing. State is not seriously contesting. They have admitted they had recommended for appropriate pension, but the Ministry of Law and Justice, Government of India decided otherwise. আছি দেব বলছি দেখছি নামটা রাখো তো কে আছে যাচ্ছি দেখছি বলছি ওই রিসিপ্টটা দেখো না ভূদেব তো মিস্টার ভূদেব চ্যাটার্জি was appearing. The Lordship kindly, if it so pleases, keep it on next Friday. In the meantime, I will put the gentleman once again under notice. 138 to 138.
Respondent number 4 has submitted one report.
Yes, yes.
Respondent number 4.
Question number 4. Union is India, 1. Union of India is 1. State of West Bengal and AG West Bengal, 3 and 4. The presence of 2 and 4 is required.
Okay, report in the form of affidavit by respondent number. By Mr. Bhudev Chatterjee, learned advocate.
My Joshua Dixon, not Dixon. There's a change in the panel also, is it? Change. Tell Ministry of Law and Justice.
Okay.
But I am afraid the panel has changed. There's an altered law. So I may have to serve a notice on the.
Yes, you serve a notice.
In the office. Notice service code.
Okay. Please take down. Petition is represented to learned advocate Namtanian. None appears on behalf of the respondent number respondents. Full stop. The matter is otherwise ready for hearing. The petitioner is to serve a notice upon the respondents, informing the fact that the matter shall appear in the list on 5th of July. Next week, Friday, under the same heading and same poison.
And let it kindly retain the position.
Yes, same poison.
Hanging fire since 18.
Yes.
And Lordship kindly record my submission of these rejoinders. I have filed the rejoinder, that may be kindly.
Okay.
Rejoinders.
Rejoinder.
দুটো আছে
rejoinder.
দুটো আছে
Okay. Rejoinders filed on behalf of the petitioner. Rejoinder. Rejoinder affidavit to the report in the form of affidavit filed by the respondent number 2 as well as against the respondent number 4 separately filed on behalf of the petitioner is taken on record.
और 5 तारीख का हाउस है सो
Item number 139, I am the petitioner, my lord. My lord, in this matter, learned advocate Bhupdev Chatterjee was appearing for the, my lord, BSF, Border Security Force. And on the last occasion, my lord was pleased to direct me to serve notice upon the respondents.
Yeah.
Firstly, my lord, I have served one notice to the learned advocate who sits in Bar Association 13. He told me that he is not in the panel of the Union of India, therefore he is not now he is not in the list there. Then he will not appear. Then, my lord, I have sent a notice to the, my lord, directly to the Inspector General and the Commandant of BSF where the petitioner was working. And my lord, it is sent, my lord, on my lord Wednesday. Therefore, my lord, service is not completed. Because of that, without the respondents, it would not be proper. Because of that, they should be here. Now, ministry, I have directly sent them. BSF actually, I have served the notice to the BSF authorities, my lord. I can serve one notice to the.
Okay, please take down. It is the submission of the learned advocate for the petitioner that the service.
Yes, yes.
Let him serve first.
I have directly served to the respondents.
Now they are SSB. Now they are not BSF. All are changed as SSB. Their units has been changed.
All the BSF. All BSF.
All everything has been changed.
Recently, my lord.
Quite few past there is no BSF.
But my lord. My lord. Border security boards.
Border security force has changed nomenclature. Sima Suraksha Bal.
Oh.
SSB. Their unit has been changed.
But on Wednesday, my lord, on Wednesday, I made a telephonic call to the, my lord, office of the Inspector General of the BSF, and from that office they have provided me the, my lord, the phone number is also here.
You serve.
Yes. I shall serve Union of India.
Let us see what will happen.
Yes.
Very good. Petitioner that the service is not complete. Let the matter be adjourned today. Place the matter on next Friday. That is the 5th.
Lordship. Ministry of Law ke diye do. That will be better. Yeah. Ranjan.
Item number 140, I am for the petitioner.
For the respondent, Union of India, my lord.
করবে ব্যাপারটা দেখো যদি না করো তাহলে টাইম নাও
Time আজকে
বলো তুমি তাহলে বলো
my lord, if possible, my lord, kindly make it not today, my lord.
You are appearing for the Union of India.
Yes, my lord. I am appearing for Union of India.
What is the status of the pleadings? Complete?
My lord?
Pleadings regarding affidavit or proposition, anything?
Yes.
Report?
Everything is ready.
My lord, all the documents, because the brief, we have presented all the records.
Take the mic.
Record and briefs is.
How many times they will serve? After your changing, they again will be served. Then how many times you must have the copy of your affidavit?
2 weeks time.
4 weeks time?
No, 2 weeks time. 2 weeks হয়ে যাবে.
What is the matter about?
This is a criminal proceeding is pending against me. On the self-same and identical allegation, my lord, they issued the charge sheet.
both the witnesses before the criminal proceeding and the departmental proceedings are same. So disclosure of evidence on that ground, my lord, I moved the writ petition, and the Honorable Justice Dr. Sambhuddha Chakraborty was previously satisfied, and my lord, his lordship passed an interim order. Thereafter, my lord, during the
interim order regarding stay of the departmental proceeding.
Now, my lord, during the pendency of the departmental proceeding, again they, my lord, issued another, my lord, notice to me that apex court held in a criminal matter that within 6 months, if the matter was not had, stay is automatically vacated. On that ground, they say that 6 months have already been passed, so we will proceed against you. Again, my lord, I made an application for further extension of interim order. That came up for hearing before Justice Amrita Sinha. His lordship was also here. No, the apex court judgment is not applicable in this matter. It is a writ matter. There is no nexus with the criminal proceeding. So, interim order will continue until further order. This is the position. Affidavit, reply, everything is ready.
Everything complete. Very well. Very short matter is there. So, what is your submission? So, come on 12th then, 12th of July, Friday. Very well. 19th.
19th. 19.
And accommodation is sought for on behalf of the Respondent Union of India. According the matter is urgent today. List the matter on 19th under the same heading and same position. নামগুলো নিয়ে নাও সব।
Lordship 141 to 146, Your Lordship, I'm appealing for the petitioners. These matters are regarding the non-payment of the pension under Calcutta Street Transport Corporation Death Cum Retirement Benefit Scheme, Your Lordship.
141 to 146.
Lordship, these are analogous matters.
7 matters.
Lordship directed me on the earlier occasion to serve notice to Mr. Sen, Your Lordship, who is appearing for the Calcutta Street Transport Corporation. Here is the notice, Your Lordship, and my learned junior friend is appearing. Now, Your Lordship, what happened, Your Lordship? The item number 141, Your Lordship. It relates to family pension. Her husband, it's my contention before Your Lordship that the husband of the petitioner exercised his option, but even though the pension has not been released, because this scheme is a option-oriented scheme, Your Lordship. And this regulation 64 of the same scheme says that whenever you exercise your option, it is the duty of the employer to convert you from CPF to GPF, Your Lordship. My condition before Your Lordship that this pension has not been disbursed to her, but this family pension is not disbursed to them to the retired employee of the Calcutta Street Transport Corporation, Your Lordship. On the earlier occasion, my lord will see the earlier order of my lord that they have not filed their affidavit in opposition till date. So they have to file their opposition, Your Lordship.
You file the opposition? Give him a copy. Give her a copy.
Okay.
You want to reply?
May I pray, Your Lordship? I have to go through it. Lordship, may I, Your Lordship? This item number 141, I am receiving this opposition now, Your Lordship. But this item number 142, 143, 144, 145, and 146, these 5 matters, Your Lordship, everything is complete. Your Lordship, they have filed their report, and I need not to file the rejoinder as because, Your Lordship, they have annexed the option form. So it is clearly clear that I am covered by this DCRB scheme, Your Lordship. And the coordinate bench of this honorable court and the self-same issue, Your Lordship, passed this order. Because of the similar issue, Your Lordship, the coordinate bench passed an order in favor of me that when you have exercised your option, you are entitled to get the pension, Your Lordship. Calcutta Street Transport Corporation referred an appeal to the division bench. The division bench, they failed. Then they again made an SLP for the honorable apex court. That also the SLP was dismissed. So, Your Lordship, the coordinate bench in 2024 only, Your Lordship, 4th of January 2024. Based on that judgment, Your Lordship, my Lord Justice Raja Basu Chodri has passed the order on the similar issue, Your Lordship. There is nothing new, nothing old in that. The toto, Your Lordship. The petitioner exercises option. The option form is there in their report. So, Your Lordship, you have to file the rejoinder. So, I am only praying that my Lord, if my Lord desires so, but the learned senior friend is not there, Your Lordship. I don't want
Next week?
Next week. Or any day, Your Lordship, as per orders, my Lord can fix this 5 matters. 142, 143, 144, 145, 146.
Only Friday I am taking these matters.
Lordship. Next Friday, Your Lordship, all the 6 matters.
Okay. No, everything is ready on other matters.
Copy has been served, Your Lordship. They need to file this before the.
You file it.
Lordship, one thing more, Your Lordship. I'm praying for indulgence, Your Lordship. This item number 145, Your Lordship. My Lord, can you see item number 145? There is a can, Your Lordship. This can is for is an application for restoration, Your Lordship. The application has been filed within time, Your Lordship, and I think they will not oppose the prayer for restoration, Your Lordship. So, my Lord, kindly pass an order for restoration, Your Lordship. May I, Your Lordship? Joydev Dotto versus State, Your Lordship. This is the can for application for restoration. So, if my Lord can pass only one line order, Your Lordship, the restored.
No. Are you ready with the oppositions? All matters. No. No, you have already filed 141.
141.
And other matters regarding 145, 146? এটা হচ্ছে 140 এর 142 তে হবে 142 তে ঢোকান এটা নেক্সট
Not want to intend to file me rejoinder. So it's settled.
This is then 145, 146.
145, Your Lordship, I'm having a can, Your Lordship, application for.
And 146.
And 146 is an, there is also a can, Your Lordship. That is an application for substitution, Your Lordship. 146. So may I pray before Your Lordship to allow these 2 applications? That is 145. So
Just right. Just right. তাহলে 142, 143, 144 পেলে না বুঝছে তো affidavit in opposition filed on behalf of the respondents is taken on record. Learned advocate appearing on behalf of the petitioner submits that he shall not use the reply rejoinder to that
exception
rejoinder or exception against the affidavit in opposition. According the matter is otherwise ready for hearing. Let the matter fixed for hearing on 5th of July.
Lordship.
The same hearing.
Lordship, my Lord, I'm not talking about 141 because I have just received the opposition copy, so I don't know what is there, Your Lordship. But item number 42, 43, 44, 45, 46.
That cannot be taken like that.
Lordship. Okay, Your Lordship. If it is there, okay, Your Lordship. I made my submission orally, Your Lordship. Lordship.
141 to 144. Give me 145.
140.
This is 141 to 144. Not 146. 145 mark করতে আলাদা করে সময় করা থাকলেও হবে না, এটা 145 146 আলাদা হয়ে যাবে, আলাদা অর্ডার বুঝলি? হ্যাঁ, সে করে দিতে পারো তোমার কিছু করে দিতে। এইগুলো আলাদা order করতে হবে। চারটে হেডিং করবে আলাদা করে, এই দুটো আলাদা করে পরে একসঙ্গে অর্ডার করবে। 145 can 1 of 2019, old can 7499 of 2019. This is an application for restoration of the instant read application. It is the submission of the learned advocate for the petitioner that the learned counsel was engaged in another court, so he could not appear before this court on call. Accordingly, the instant read petition was dismissed on 15/7/2019. He prepared for necessary order for restoration. Had the learned advocate perused the body of application being can 1 of 2024, 1 of 2019, considering the submission and also considering the body and prayer of the can 1 of 2019, the instant can application is allowed with a direction that the interim that the order of dismissal passed by this court on 15/7/2019 is hereby recalled. Full stop. The writ petition be restored to its original file and number. Let the matter appear in the list on 5th of July.
Lordship, from my record, I find there is a rejoinder affirmed by the petitioner. Lordship, let it be kept on record.
What?
Rejoinder
In
to
which
the
matter?
report.
Which matter?
145.
145.
As because my lord is dictating the order. 145.
Rejoinder file on behalf of the petitioner.
Lordship.
Be taken on record. Give me 146.
Lordship. 6.
Yes. Is it all 146? Where is the can?
Yes, Your Lordship. This is a can application for substitution, Your Lordship.
No, can is not there.
And number there actually. So,
Please take down. Can 1 of 2024 is running in the list. The can is not placed with the record. Department is directed to place the record on 5th of
July.
5th of July.
Lordship.
Next.
Lordship, I'm grateful, Your Lordship.
Reply to the affidavit in opposition by respondent number 4.
So what can be done? Let it be start today.
Short point by tell your lordship that I was a copying clerk of the Alipur district judge. Now, on the eve of retirement, I had to fill up the pension form and I had to put up the name of the nominee. I was married to one Mrs. Shikha Chatterjee, my legally married wife, but at the time of filling up the form, the nomination form, one Mr. Devasri someone has been incorporated as my cousin, but subsequently it was found by my wife that this is not her wife, but a second wife during the subsistence of a marriage. First marriage. Now, Millard, I have taken a plea that I have two pleas, Millard. First of all, Millard, that there was a manipulation in the record. And number two, the charge sheet was filed and served, Millard, after Millard, the charge sheet disciplinary proceeding after the date of retirement. The rules do not permit them to proceed against me, Millard, after the date of retirement because there has been cessation of relationship employer and employee. The registrar of the court, Millard, had filed an affidavit stating inter alia during the subsistence of the inquiry proceeding that no, this was a mistake on the part of, there was an evidence in the inquiry proceeding that my contention became true. Millard, in order to, Millard, demolish such evidence, Millard, an affidavit was found, Millard, in the proceeding, Millard, by the registrar of that court, Alipur court, Millard. The learned registrar says, Millard, that was a mistake during this inquiry, in the deposition, Millard, made during the inquiry proceeding, which was sought to be corrected in this proceeding. Okay. Be that as it may, Millard, I said that when such attempt is being made and registered is the highest administrative post in any court, Millard, so this affidavit would clearly suggest that the disciplinary authority, being my employer, would not be able to, Millard, conduct the disciplinary proceeding in a fair and reasonable manner because it smacks of, Millard, certain bias. Because I tell why, because the registrar should have said that if the deposition is made or not, that should be an outcome of a cross in a proceeding, but not in this way. And first and second, Millard, whether after the retirement, Millard, the proceeding could be continued or, Millard, or commenced. Because in case of a financial, Millard, irregularity or, Millard, the financial loss caused to the employer, Millard, if the rule permits, then, Millard, there are certain proceedings, there are certain rules which permit the employer, even if, Millard, after in the bank also, Millard, yes, Millard, that can be. And, Millard, your lordship knows in bank SBI regulations, there is specific provision for the purpose of disciplinary proceeding. After retirement, the employee should continue till the disposal of the inquiry. So this is there. Millard, in absence of any rule, the authority cannot proceed. Be that as it may, Millard, it was my fault that I did not file the affidavit in time in the court, since I took
in respect of the disciplinary proceedings, my lord, state will, my lord, can say that we are appearing for the Auditor General, and in this respect we have nothing to say. But, my lord, some facts were, my lord, suppressed because, my lord, the Shikha Chatterjee, my lord, written a letter to the AG department that the petitioner did not, my lord, fail to obtain the, my lord, divorce decree. That is still pending. And Shikha Chatterjee is still, my lord, wife of the, my lord, petitioner. And secondly, my lord, Shikha Chatterjee filed one writ petition, my lord, for attachment of pension, my lord. That writ petition number 20456 of 2018.
Is there any order?
I don't have any information, but I have to see.
Okay. It was subsequent to the writ petition, how the question of material suppression of fact. And I said, Millard, I had a compatibility conundrum with my wife. I filed a divorce suit. I lost. I preferred an appeal. Everything.
We have, my lord, sought, my lord, all the, my lord, documents from the state authority. But till now, my lord, they have not.
Millard, bigamy is an offense. If it is proved, it's them. Millard, that is why the disciplinary proceeding was initiated. Millard, AG Bengal is only a disbursing authority with regard to my pension. Whether I have one wife or two wives, Millard, that is a subject matter of a disciplinary proceeding, and my wife will come and will depose, and the other authorities will come. Because
but unless, my lord, we get
and question is whether after retirement, Millard, whether the authority will embark upon such inquiry, whether it amounts to a roving inquiry. If I have two wives or not, Millard, that is a matter whether after employment, Millard, the authority could embark upon such inquiry. Whether this inquiry is necessary or permitted under the law.
So next week.
So, but, my lord, it is very much necessary, my lord, to be present because, my lord, unless they, my lord,
কি বার বলছিলেন? শুক্রবার কি নাম? হ্যাঁ সীমা সিনিয়র অ্যাডভোকেট হ্যাঁ তাহলে পরের শুক্রবার কি বার? কত তারিখ?
Next week? Next Friday?
Friday week, Millard.
Only Friday week.
হ্যাঁ তোর ইচ্ছে 100 তো বেশি বলেছি
আমার বোঝাচ্ছে
সব Friday. All right. If you want, she is very cooperative. Affidavit of service and the direction was there by your lordship's court to file affidavit, communicate the order, mirror. We have communicated the order long back. 14 June 2018, Miller, there was an order passed by the honorable court. এটা রেখে দিন affidavit of service টা আর রিপ্লাইটা জমা দিয়েছি।
Okay, affidavit of service filed on behalf of the petitioner is taken on record. Top. Next, affidavit in reply on behalf of the petitioner to the affidavit in opposition on behalf of respondent number 4 is also taken on record. Matter is otherwise ready for hearing. Let the matter appear in the list under heading of hearing on 5th of July or 12th.
Let's start 5th of July. If I have difficulty, yes. Kindly accommodate for 1 week. If suppose if I have difficulty, kindly
let them start.
Yes, yes. At 148, I pray for 1 week adjournment, or 2 weeks. Because the old matter, the brief is not available in such only 2 weeks. 148, I pray for 2 weeks adjournment. The brief is not given.
An accommodation is sought for on behalf of the petitioner according the matter is urgent today. List the matter on 19th.
I'm deeply obliged, Miller.
আগের অর্ডার আছে এখানে not today. Next.
I have got the petition. Your lordship kindly fixed the matter on 19th July because one matter was fixed on 19th July. So your lordship fixed this matter also.
Okay.
19th July.
Are they similar matters? No.
Not similar matter. Okay. This is a matter arising out of a departmental proceeding. Punishment was issued. Passed. Appeal preferred. Appeal was dismissed. So it will be, the matter will be heard on merit.
Okay. Please take down.
Stop.
An accommodation is sought for on behalf of the petitioner. According the matter is urgent today. List the matter on 19th.
July.
Madam, for the petitioner. Madam, affidavit in opposition has been served upon me by the respondent. Madam, I also used my reply. So you can allow me, I can file.
Where is the affidavit in opposition?
I think they have not filed before.
They have not filed yet. You just keep it.
Now, if you also show one, I can serve further notice and come back. Because I served notice before mentioning the matter before your lordship. This is the notice. I have served notice before mentioning the matter. Now, I shall further serve them if you so desires.
Please take down. Learned counsel appearing on behalf of the petitioner submits that he received the affidavit in opposition on behalf of the concerned respondent authority. Such affidavit in opposition is not placed with this record. the petitioner is ready with the rejoinder stock reply to the affidavit. However, next part. None appears on behalf of the respondent authority. Considering the situation, it further appears that the notice has been served earlier to the mentioning this matter by the petitioner. Considering the absence of the absence of the respondent authority, the petitioner is further directed to serve a notice upon the petitioner, informing the fact that the matter shall appear in the list on 12th.
I am appearing on behalf of the petitioner. It is a very simple matter. The petitioner was an ex-employee of Calcutta Municipal Corporation. He retired in the year of 2014. PPO, most unfortunately, PPO was issued in the year of 2017. That is after completion of 3 years. And retired benefits was released after 35 months from the date of retirement.
So why you are here?
It was. It appears from the PPO that some amount of money has been deducted.
Some amount of money?
Money has been deducted by the authority. And
refer me the page.
ELRCs kindly come to page 32. It is only license fees had been recovered from his retirement benefits. Party has not been maintained in my case. A copy of the state deduction. So no, sorry. That is page 29. Page 29. Total claim 75578. 79,578. Yes. It was taken on penal measure. Actually, license fees is 7,920, and it has been deducted 10 times of the license fees. My contention is that after retirement, the authority can deduct the amount from the retired benefits. I've already annexed the judgments delivered to the Honorable Supreme Court. That's the last annexure, page 33. Next. And second submission is that delayed payment of retired benefits. That is, the petitioner is entitled to get the interest. Next. First is LRCs kindly come to page 33.
Now, where is the respondents?
Respondents several times it was intimated. Lastly, it was heard by Honorable right on 22nd May 2024, but they are not interested to contest this matter. LOC kindly fix the matter and decided it in.
Come on next week then.
Yes.
You serve notice.
Unfortunately,
you serve a last notice. No, this matter appearing in the list after 2019.
Yes. Several times it was served, notice was served, but they are not interested to contest the petitions. Unfortunately, the petition is suffering since for a long time being.
I understand. Please take down.
Fees is not next week.
Yes.
In the meantime.
This matter is appearing after 5 years in the list. Learned advocate to the petitioner submits that several time notices were served upon the respondent authority, but they did not. They chose not to appear. Considering the situation, the petitioner is further directed to serve notice to the respondent authority, informing the fact that the matter shall appear in the list under the heading of hearing on 5th of July.
I'm grateful to.
My lord will now take the original side matter, my lord. At 1 p.m., my lord had fixed for matter.
1 p.m. After writing.
The officers have.
But fail to express his mind. That the Indian order is going to be extra on
Monday. Then come on Monday.
This Monday.
This Monday.
First July.
So the
appear on first July as after the extension of
group 8 matters.
Group 8 matters.
Give me the slip. Okay. Sombar test for the 2 minutes. 2 minutes. Yes, which matter?
Yes, my lord, item number 2 of the original site.
Item number 2.
Yes. My lord, the reason for making this application, my lord, the original order was passed in 1st of May 2024, my lord, protecting the writ petitioner against a penal imposition by the Indian Oil Corporation. The writ petitioners are LPG dealers of Indian Oil Corporation. Now, that interim order, my lord, technically ended on 27th, that is yesterday, my lord. And this application was filed on 24th. Because of some technical delays, the matter could not be listed in the meantime, my lord, but I have been mentioning before your lordship, and now today the matter has come. The difficulty is that if my lord does not extend the interim order today, then automatically this software will deduct this penal imposition, my lord. We'll finally come to see at page 7 of the order.
In view of the restaurant for the bridging the balance. Okay. What is the balance penalty amount?
The balance penalty amount is 1,43,102.
What is the penalty amount?
Well, this is the penalty amount which is to be deducted from my business account. And the Honorable Court was pleased to stay this deduction.
Okay, you challenge this order.
I have challenged this order.
Okay. Please take down.
And my lord, the parties have exchanged affidavits. It is ripe for hearing.
This is in respect of GA only. Right? GA 1 of 2020. This is an application for extension of interim order passed by this court on the earlier occasion on 1st May of 2024. Or the learned advocate. Where is the service?
My lord, I have already served. My lord, these are the branch of your communications which has been made since 24th of this month. Every day, my lord, I have been reminded. Even today, after mentioning in the morning.
Very good. You will heard the learned advocate. There is the body and prayer of application being GA 1 of 2024. Having heard the submissions, the GA being 1 of 2024 is considered allowed. Full stop. The interim order passed by this court on the earlier occasion is further extended till 8 weeks from date or until further whichever is earlier. Full stop. It is the submission of the learned advocate for the petitioner that the matter is otherwise ready for hearing. Let the matter listed for hearing on 26th of July at 2 p.m.
My lord, I am led by Mr. Shomu Mujumdar.
My lord, we will not take away any appellate side matter anymore today. Appellate side matter will not be taken up anymore.
No, today I'm taking the appellate side matters since 13:15.
Yes, I have seen, Lord. My lord, only request, my lord, 178.
Okay, let me take up the matters. Just wait.
Wait, my lord.
Yes, do so.
I'm good.
Call next appellate side matter.
156 হয়ে গেছে ওটা তো। কোনটা লাস্ট হবে? লাস্ট হচ্ছে, ঠিক আছে ঠিক আছে। One 56. Who is appearing in the list? None appears on behalf of the petition. Let the matter be urgent today. List the matter on 5th of July. In the absence of the petitioner on the urgent date, the necessary order will be passed. Next. In the absence of the petitioner on the urgent date, the necessary order will be passed.
Well, the matter appeared on last Friday, that is on 21st of June, and your Lordship's direction was to serve a copy upon my learned friend. In compliance with your Lordship's direction, we served a copy which has been received as late as the 25th of June. There are two other earlier orders, and in terms of those orders, they were to produce the records, as I appraised your Lordship last occasion. But may I proceed?
You can proceed, but where are they? Without the report or the order. Yes, you can place your case.
May I please, Your Lordship?
Yes.
Well, the application arises out of an order passed in a departmental proceeding. Well, the petitioner was a bank employee.
Petitioner?
Was a bank employee.
Okay.
While he was in service, that is in the year 2011, he was served with a show cause notice. Show cause notice. He participated in the proceeding, and his total case is he was not responsible for the preparation of the papers as are being alleged against him. There was a evidence section, witness section, and in the witness section, through the bank manager, proved his case to have not been responsible for the purpose of preparation of the paper. Nevertheless, he has been punished. My Lord, may I in this background place the case? Lordship, kindly come to the charge sheet. That is to be had at page 178 on.
Page 178. 178.
Statement of article of charges are to be had at page 179. First charge, it is alleged that you had not verified the KYC documents, photographs of the applicant borrowers to ensure their genuineness for availing produce marketing loan before recommending sanction of the 58 PML as per list number 1. Now, to make it clear, their allegation is that is as if I was responsible for the purpose of papers to certify the borrowers to be eligible to take the produce marketing loan.
Verification of KYC documents.
By you of not verifying the KYC. My state case was that I did not do the verification of the KYC. It was done by other officer. It was done by other officer. Fortunately for me, no less than the bank manager of the relevant period deposed as the DW1 that yes, it was done not by Mr. Debra, it was done by another officer. And while this matter was cropped up before my Lord Mr. Bosu Chaudhary, we pointed out that in spite of such deposition, that another officer had not been called for, or he has not been, or no departmental proceeding was started against him. Officers of the bank was proceeded with in departmental proceeding, namely the branch manager and myself. That is why my Lord called for telephone. That is why my Lord called for telephone. But it be that as it may be, next charge is it is alleged before recommending for sanction of the above PMLs, you fail to carry out meaningful pre-sanction inspection. At the residence of the applicant borrowers, list A, and the documents obtained to verify their vocation to establish their eligibility for availing produce market. Well, it is contingent on charge number 1. It is contingent on charge number 1. If it is held that I did not do anything regarding the KYC verification, there cannot be any meaningful inspection. Charge number 3, it is alleged that you have failed to obtain the endorsement of the borrowers of the cold storage receipt issued by the above private cold storage in favor of the bank before recommending the above PMLs of list A for sanction. It is also related to charge number 1. Charge number 4. It is
whether it is related to charge number 1?
Yes,
It is for obtaining endorsement on the borrower's receipt.
Borrower's list A. That list A. List A contains the name of the borrower. List A contains the name of the borrowers. Charge number 4. It is alleged that you had obtained corporate guarantees of Messrs. Bijoy Narayan Cold Storage Private Limited and Messrs. Seema Cold Storage Private Limited for PML sanctions against their respective cold storage receipts without obtaining their board resolution. But as your lordship knows, these types of loans are catered by the cold storage. Their department's cases, yes, there is guarantee from the cold storage, but you have not obtained the resolution of the directors. You have not obtained the resolution of the directors. I would try to, my endeavor would be to place that all these things were done by seniors, namely the branch managers. Now, my lord, the important clause is, important charge is charge number 5. It is alleged that you have disbursed of the above PML of each day through cash payment in the system without physical verification of the cash. Cash deposits were shown and made to the respective cold storage accounts instead of disbursing the same to the respective borrowers, violating the bank's laid down instructions. My lord, may I explain this? Allegation is that as if I distribute the money through cash without following the bank notes. This is, kindly appreciate this. Kindly appreciate, you had disbursed. Personally, I disbursed. Evidence is defense witnesses deposed that it has not been done by me, it is done by the branch manager. It is done by the branch manager. Why it has been ignored? This witness statement has been ignored because there is no corresponding record. But branch manager has heard, yes, it has been done by. This is the position. And all I would be, whether in spite of sufficient defense and witness deposition, ignoring the witness statements, I have been punished on. That would be my endeavor. These are all on record. These are all on record. Lordship, kindly come to next chart. It is alleged that you have not conducted meaningful post-sanction inspection and follow-up for recovery of the outstanding in PMLS list. My case is, it was not my responsibility. All I did the appraisal work. Nothing more than this. Pre-sanction, post-sanction payment was done by other officers.
What was your post in the bank?
My post was field officer.
Field officer.
Field officer. Field officer. Next charges. Due to above acts of negligence and non-compliance of the bank's laid down instruction, the total credit of rupees 5.8 crores has become bare and doubtful of recovery, and the bank is liable to incur financial loss to the tune of 5.77 crores plus interest outstanding as on account, half of which, namely rupees 2.88 crores plus interest loss is attributing to Sri Debra Kanti on the Apurva. These are the 7 charges. My lord, the matter was proceeded with before the inquiry officer, and your lordship will get the report to the inquiry officer. Incidentally, lordship, first of all, kindly, before I take your lordship to the other part, kindly come to page 83, 183.
Today we don't have some time.
Yes, my lord. Lordship, kindly keep it subject to your lordship's permission. Kindly keep it in the top of the list. I may be taking some time. That is why.
The next, we get a part of Daklam item. Matter hard in part. Highlight একটা matter next highlight এর part রাখলাম 5 তারিখ প্রথম এটা 5 তারিখে রেখেছি আচ্ছা matter hard in part let the matter 26 তে কোনটা 5 মিনিট যেটা বড়টা শুনলাম তো এটাই রেখে দাও ঠিক আছে ওকে matter hard in part let the matter fixed on 5th of July as a part matter on top.
My lord, a matter was mentioned for extension of interim order in a writ petition. My lord, I was for the respondent. I was given a notice that your losses intends to take up the matter at 1 p.m. today, my lord. WPO, my lord, it is for extension of interim order WPO 370 of 2024. But I am for the respondents. We have given notice.
You are not visible. You are not visible, sir.
Lordship,
the matter was already taken up at 1.
Lordship, matter was.
Yes, matter was taken at 1.
Lordship, then may I?
I was logged in.
It was taken up at 1.
Lordship, it was mentioned that it will be taken up at 1.
Yes, I have already taken up this matter. Order has already been passed and won.
Or even losses may losses may kindly take out fix the matter for hearing, because the affidavits are already exchanged and we are suffering an
Yeah,
interim.
I already fixed the matter for hearing.
Lordship, then may I file my affidavit in
Come
opposition?
on that date.
Obliged, Lordship.
I am appealing for the response.
My lord, I do appear for the petitioner in this matter. This is a matter, my lord, where we have filed a writ petition in the nature of a judicial review challenging an order of passed by a disciplinary proceeding. Now, this matter, which I should indicate at the very outset, was heard substantially by Honorable Justice Rai Chattopadhyay. Various orders, my lord, will just please that. The hearing is more or less concluded. I have made my submission. My learned friend have also made my submission. Only 1 day was left for me to conclude the submission and rest the case before the court. And at that juncture, my lord, determination was changed, my lord, and matter was assigned. Now, if my lord hears it, then we will have to start it afresh for a hearing, or the matter has to go before the Honorable Justice Chattopadhyay. We have to pray before the Honorable Chief Justice for an assign.
Better for you to move before this court. Okay. So I'm delisting this.
My matter has to be released by my lord with a direction, with a request to the Chief Justice to assign it before the appropriate bench. Because on the ground that it has been heard by Honorable Justice Chattopadhyay, so I don't
Okay. It has been submitted by the parties, submitted by the learned advocate for the parties, that the matter has been extensively heard by the earlier bench, having determination.
Yeah, Honorable Justice
considering the submission, the matter be released from my list. Let the matter be placed before the Honorable the Chief Justice for assigning this matter to the appropriate bench.
It's my ill luck, my lord. I could not argue the matter, but I will certainly have a matter, my lord, where I can
have some other matters?
Yes, certainly another matter, a new fresh matter where I will get an opportunity to argue before my lord. Great. Yes, I do. I take you honestly.
First call. Next.
My lord, item number 4, my lord, I beg to appeal for the petitioner, my lord. Mr. I am led by Mr. This is an application of section 34 challenging from an order passed by the learned tribunal, my lord. But I am led by Mr. Sen, my lord, today during the bar operation of the bar library, my lord, Mr. Sen is engaged, my lord. Mr. Sen has requested if I can, my lord, can please keep the matter any other day, my lord.
Any other day means next
week,
Friday? Next Friday at 2 p.m.
My lord, can it be there on next Friday week, my lord?
Friday week. Good.
No, we are seeking adjournment because Mr. to the engagement of Mr. Sinman.
Please take down. An accommodation is sought for on behalf of the petitioner. According to the matter is adjourned today. Place the matter on 12th. 12th of June.
Grateful.
Should do 4, 5, 6 in person. I know 5.
Your Lordship, in item number 5, it's a section 34. I'm led by Mr. S.N. Mukherjee in this matter. Mr. Mukherjee is like on his legs in before court 23. So if this can be kept on some other date, Lordship. And the item number 6 and 7 are arising out of the same arbitral award. It is a challenge of the same arbitral award dated May 19, 2016.
I understand.
So
the matter has heard extensively from your part. Okay. So today is it not possible?
Today, Your Lordship, he's caught elsewhere. So any other date, because this matter was supposed to come up yesterday. Like as per Your Lordship's direction, it was supposed to be listed on 27th. But in view of the fact that original side matters are taken up only on Friday, it is appearing today. So if Your Lordship can kindly tag all the 3 section 34 so that we can start on the next day.
The difficulty is I have already heard this matter. So I want this to conclude.
No, no, your lordship, like section 34s, we have not started. We have made submissions on the execution,
Yes.
which we did on the, which is kept next on 5th. But the section 34s, we have not yet started our submissions.
That is the separate matter. I have started the execution.
Yes, your lordship, which is about to come up on 5th next.
Item number 5. And as far as item number 6 is concerned, the petitioner has been delegated to ICC.
No, you have argued on the matter of item number 4. That is the execution matter.
No, your lordship, item number 4 is a section 37, which is concerning a new arbitration.
Okay.
These have not been debated as yet.
So all the 4 matters today have not been, we have not commenced our submissions before your lordship.
You submitted on the matter that was fixed on 5th.
Yes, my lord.
Yes.
And that was execution 457 of 2018. And that is
And these are the section 34 and 37.
item number 4 is 37, and the rest 3 items are arising out of section 34. So my humble submission is, my lord, now she says that Mr. Mukherjee is appearing in item number 5.
In item number 5.
6, the petitioner is not appearing because they have been under CIRP and IPC. And the next item is again 34. There Mr. Mukherjee is not appearing. It's my petition. If your lordship allow, I can start my submission.
Your lordship, on previous occasions, like may I indicate that all 3 section 34s are arising out of the same arbitral award. And our application, which is AP 698, is the item number 4. Mr. Surana's application, Mr. Surana's petition is the AP 822, which is item number 7. So we have filed the section 34 first. I'm kindly praying that Mr. S.N. Mukherjee is already submitted on prior occasions before different benches. I'm just submitting that all these 3 matters be tagged together and they be kept on the next occasion, like on 5th July.
Whether Mr. Mukherjee is there in the item
He
number
is
5
available on 5th July.
in item number 5 and 6?
Yes, your lordship.
Mr. Mukherjee has appeared earlier in item number 5, that is 698.
698.
All these 3 matters are emanating from the same arbitral award.
What can be done today? What can be done? Do you want to argue?
My only fear is below. Respondent number 1 and 4 have already been under CIRP. Respondent number 2 and 3, they have got amalgamated and they have now become respondent number 2. They are only there. God knows when they will also be under IBC.
No. They have started.
It's just a speculation at this stage.
I understand.
Like,
Possible on Monday to
Monday, Tuesday.
something your lordships can be used. My humble request complete
Affiliate site के watch. Diary को third देखो 3rd of July की है 3rd और second अभी भी छोटा सी
37 करने के लिए तैयार है 37 I can do but the 34 I
out of July ना second day
करेंगे ना 37
कुछ नहीं
ठीक
second July
next 698 कर दो मेरा leader है ना उसमें 37 and
Okay.
so I can do that
2nd July
मतलब
at 3
second
at 3
Madad, could it be 5th July, Madad? Because Mr. Mukherjee, I think my junior friend has already told your lordship. Could it be 5th? That's a Friday also, which when your lordship takes up original side matters. And in fact, on that Friday also, my lord, the execution matter also, which Mr.
Execution matter fixed on Friday.
Yes. So along with that, my lord, this is also related to that. So if your lordship,
No, I have to hear the execution matter on 5th.
Very
I
well.
want to start this matter earlier to that execution matter. So I want to fix this matter on 2nd.
But
2nd of July.
I have no difficulties in that, my lord, personally speaking. The only thing is, my lord, the former Advocate General is leading me in this matter. And since your lordship...
Okay. Already fixed 3 on matter at 3 p.m. Very good. Then it will become at 3rd of April, 3rd of July.
3rd July, my lord.
At 3.
My lord, in case Mr. Mukherjee, I don't know, my lord, but in case Mr. Mukherjee is in some difficulty, my lord, kindly accommodate me on that
Okay,
day.
no issue.
That is my only
No issue.
request.
Please take
Otherwise,
note.
my lord, no difficulty.
In all matters, item number 4 to 7.
37.
কোর্সটা হ্যাঁ ওটা তো ছেড়ে দিন ছেড়ে 5 to 7 5 to 7 5 to 7
Item 4 is perhaps on the 12th of July.
12th of July. 5. An accommodation is sought for on behalf of the petitioners.
So, 37 wala? 12th.
Let the matter be adjourned today. List the matter on 3rd of July at 3 p.m. as a specially fixed matter. Okay. 3rd of July.
Grateful, my lord.
Another segment.
Your Lordship, in item number 8, I am appearing on behalf of the respondent corporation.
Who is for the petitioner?
Your Lordship, in item number 8 and 9, I am on behalf of the respondent corporation. Your Lordship, if I may,
Yes, what is your submission? Connectivity is poor. Pass it over.
Your Lordship, an appeal has been preferred by
First call. Come on, second call.
Bengal Transport.
Item number 9, Your Lordship, Mr. Partha was appearing for the petition. So due to some medical issue, he is not going to appear.
The order
Or not today.
of the Lordship, hence the order of
Do you know?
Lordship, I don't have a brief right now.
Okay, not today.
Great.
In item number 10, I am appearing for the Board of Trustees. There are two other repetitions are there on the same cause of action.
What are the issues?
Issue is, direction for deduction were made during the pay revision.
But I'm for the petitioner, my lord. My lord, I'm appearing only in this matter. I'm told that I've received instruction that the other two matters are not exactly same, but it has some relation, not exactly same. My lord,
They are enjoying based on the first one.
my lord, this matter is now ready for hearing. Affidavits have been exchanged, my lord. The issue is, my lord, there was a pay scale in the port trust, my lord, that is a little different from the standard pay scales in the other PSUs, Central Public Sector Undertakings, my lord. it was decided to the port trust pay scales will be converted into the standard pay scales along with the other PSUs. But these resulted in some benefits were given to the employees because their pay scale were changed, and bunching effect was given. Bunching effect means the increments were given, and this created an anomaly because, my lord, the juniors have started getting more pay than the seniors. This was the anomaly. Now, my lord,
So what are the other matters?
other
All of the other matters are all similar. The first one was moved in 2006 by a group of big petitioners. Interim orders were obtained.
No, I have the determination 2018 to 21.
Yes.
Whether these matters within this
Yes,
determination.
yes.
So
20
let all the matters come together.
Yes, so that no judicial.
Give me the numbers.
Yes, I have given. I have given.
Well, I am for the respondent number 2 in the matter, in all the matters.
Respondent number 2. Very
Yes,
well.
I'm appearing only in this matter. The petition is different in the other two matters. The advocate for the petitioner.
I shall inform the advocate. Department, yes.
Respondent number 2.
Yes, madam.
And you are appearing on behalf of the respondent number 1.
1.
Learned advocate appearing on behalf of the respondent number 1 submits that there are other 2 writ petitions in which the issues are near about similar. The learned advocate appearing on behalf of the petitioner of this matter submits that the all writ petitions may be heard together, though merits are not so similar. However, However, considering the submission of the parties, the other 2 writ petitions being numbered, such and such, such and such, be listed together along with this matter on 5th of July at 2 p.m. 5th of July under the same.
Grateful. Great.
11, my lord, I am for the petitioner.
My lord, I am appearing for the respondent bank in the matter. My lord, I am praying for a short passover of just 5 minutes, my lord. I intend to file my affidavit in opposition, which has been already served, and reply to that effect has already been served upon me. I just want to bring that affidavit in opposition on record.
Okay, very well.
My lord, I am praying for a short passover, my lord.
Pass it over for a while. Just wait for it.
In this matter, my lord, Mr. Sudeep Sharnal is appearing, paying for not today, only not today, upon his instruction.
Punjab National Bank. Very well, not today.
Grateful.
First call. First call.
Lordship, item number 15, I am led by Mr. Dibendra Chatterjee, Lordship. I am praying for not today.
For the petitioner.
Lordship.
Item number 15. Not today. Yes. Which for the petitioner? Yeah. Well, an accommodation is sought for on behalf of the respondent. According the matter is adjourned today. List the matter on July 12th. Under the same heading.
My lord, I am for the petitioner. My lord, in this case, my
Solo
lord,
চলছে
writ
প্লিজ
petition.
তো তখন তারা মিটে গেছে সবাই
My lord, the writ petition is of my lord 2021. My lord, Mr. Banerjee, I can see is appearing online. He is for the my lord administration. My lord, there are some subsequent developments after the pleadings were completed in 2022, my lord, which I intend to bring on record by way of a supplementary affidavit. So while I'm seeking
My lord,
leave,
I have a matter right now fixed at room number 38.
but kindly, my lord,
If may,
I am for the writ petition.
You want to file supplementary?
But supplementary affidavit because the pleadings were completed in 2022. My lord, there is a change in my post in the meantime. So I want to bring those documents before the my lord court.
And
Honorable.
what about the report or affidavit in
My
opposition?
lord, the pleadings were completed. I have, my lord, the also administration has already given, my lord, the affidavit in opposition. I have filed the reply. I have served upon him. My lord, those pleadings are complete. I am only seeking, my lord, a short leave, my lord, to file a short supplementary affidavit, bringing on record certain subsequent documents. And my lord, lordship may, my lord, then my lord fix a date for final hearing.
my lord, I really do not stand in the way of my learned friend filing a supplementary affidavit. But if my lord, is pleased, my lord, to grant such a leave, my lord, to my learned friend, kindly, my lord, also allow me an opportunity to, my lord, deal with the supplementary affidavit if, my lord, High Court administration, my lord, deems it proper.
Okay. Very well. Learned advocate appearing on behalf of the petitioner submits that since the affidavit have been exchanged in the year 2022, some subsequent development requires to be placed before this court for the proper determination of this matter. For that purpose, the petitioner intends to use a supplementary affidavit. Leave is granted to the petitioner to use the supplementary affidavit within 2 weeks.
2 weeks.
Reply, if any, thereto by the High Court administration respondent within 2 weeks thereafter.
Yes, ma'am. Yes.
Let the matter appear in the list on 2nd of August.
Very well, my lord. Subject to my lord, I am not, my lord. He may file a reply, my lord, because if it is in the form of that, my lord, then I also should get a chance to file any exception. But I am not
Let
asking.
a reply to a supplementary affidavit. My lord, let us, my lord, exchange our affidavits first. Then, my lord, if it is required, my lord, will kindly grant that liberty. Kindly do not grant that liberty today.
My lord, may I, my lord, with your lordship's kind indulgence, suggest one thing, my lord. In the meantime, if my lord required, I will only then file. Otherwise, I will not. So, my lord, liberty may be
my lord,
granted.
need not grant that liberty today. My lord, let us see, my lord, what comes, my lord, in the form of a supplementary affidavit.
You can file it on the argument date of argument option.
Very well, my lord.
Let the date be fixed on 2nd of August under the same heading.
Grateful.
2nd of August, my lord has been kind enough to fix. Grateful, my lord. Great.
Call the passed over matter, first call.
My lord, I'm appearing for the petitioner in this matter. I'm being laid by Mr. Anirban Mujumdar. My lord, there was a fire in his chamber on last Saturday, and all is in Grastin Place, and the briefs are not accessible to him.
So what is
In
your
such
submission?
situation, I'm currently seeking for an adjournment for 2 weeks.
Item number 3. An accommodation is sought for on behalf of the petitioner.
Yes, my lord. I am for the.
Okay. Due to some unavoidable circumstances. Petitioner, due to some unavoidable full stop.
Petition.
According the matter is urgent to release the matter on 12th of July. 12th of July.
Much obliged, ma'am.
12th July.
Yes.
Your Lordship, in item number 8, I am appearing on behalf of the respondent corporation.
Yes, what is your submission?
Your Lordship, this issue relates to the grant of career advancement scheme to the employees of the state transport undertaking. We are a state transport undertaking, Your Lordship, West Bengal Transport Corporation. The Honorable Single Judge Coordinate Bench of the High Court has passed a judgment in order on 9th May 2024. We have preferred an appeal against the order It has been listed as APO 95 of 2024, Your Lordship. The issues in item number 8 as well as 9 pertain to the same matter in front of Your Lordship.
Then what is your submission now?
Your Lordship, an appeal has been preferred, Your Lordship. I'm praying for till the time the appeal is disposed, Your Lordship.
Very well, not today. Come on next week.
Grateful, Your Lordship.
My lord, I am for the petition. My lord, may I file my my lord, reply? Look, the petitioner, my lord, is an employee of the opposition.
Yes.
Lord, the petitioner, my lord, is an employee of the respondent Canara Bank, my lord. My lord, he was, my lord, appointed from 11th February 2001 in Karnataka. Thereafter, my lord, he has served at several places, and my lord, on 16th of June 2012, my lord, he was transferred to the Kolkata Circle Office, and from, my lord, thereafter to Durgapur Circle Office, and from November 2014, my lord, he was again transferred to the Kolkata Circle Office. My lord, he is, my lord, his place of residence is, my lord, North 24 Parganas within the police station of Titagarh. My lord, now he was transferred. If your lordship may kindly comes to page 30.
Place of residence, not
Place of residence is North 24 Parganas within the jurisdiction of Titagarh.
Yes.
So his posting, when he was posted at, my lord, the Barakpur branch, my lord, this transfer order was issued. My lord, at page 30, thereby, my lord, transferring him from Barakpur branch to, my lord, Bhubaneswar in Odisha. My lord, we challenge that transfer order. Because, my lord, after receipt of this transfer order, we made a representation. And in that representation, my lord, I have said that my children, my lord, if your lordship may kindly takes my representation that that I had submitted.
Page?
My lord, page 32. Page 30 is the impugned transfer order. Page 32 is the, my lord, the representation. The gist of the representation that I was suffering from certain ailments. My daughter was suffering from acute lung disease. His son was studying in class 8, and the daughter is, and another, the youngest daughter is 12 years old.
Yes.
And since it was, my lord, the pandemic situation, so I requested, my lord, to reconsider the transfer so that I can, my lord, stay it at my home circle. My lord, this transfer order, my lord, was not considered at all.
Representation.
So I'm sorry, my lord. The representation was not considered at all.
So transfer order dated?
My lord, transfer order dated, my lord,
9th of July.
My lord, 1st of July.
1st of July.
Page 30.
Page 30. 1st of July.
My lord. My lord, at that stage, my lord, I had approached this honorable court.
Yes.
And my lord, on 23rd of August 2021, when this matter first came up for hearing before his Lordship Justice Arindam Mukherjee, his Lordship directed for exchange of affidavits. My lord, his Lordship was not inclined to, my lord, stay of the transfer order, and my lord, I was asked to, my lord, report to the transferred posting. My lord, now, my lord, I am placing reliance on the transfer policy of the bank. My lord, there is a transfer policy of the bank. in that transfer policy, my lord, if your lordship may kindly takes up, my lord, page 62 onwards, that is the transfer policy of the bank.
Page 62.
62 of my writ petition, my lord. My lord, transfer is an incident of service that is not disputed, my lord. This is a transferable job. It is not disputed. But there are certain, my lord, safeguards being provided in the transfer policy, which I am relying upon, my lord.
Yes.
My lord, may I read from, my lord, the guidelines on transfer policy as furnished hereunder, applicable only in respect of officers in scale 1, 2, and 3. My lord, I am a scale 1 officer. So, my lord, at page 63, my lord, I am reading the guidelines. Generally, transfer of officers from one place to other can be considered only after completion of 3 years service at branch office, except on promotion or on request by the concerned officer, that is the officer can be transferred on promotion on request administrative exigencies, even though they have not completed the minimum tenure of 3 years at a place. However, the request transfer shall be considered subject to administrative exigencies only. Normally, officers who are aged 52 years and above will not be posted outside the home state except on promotion. My lord, I am relying on this provision. My lord, at present, when I filed the writ petition, my lord, I was 51 years of age. My lord, that was in 2021. Now, my lord, I am 53 years of age. My lord, I am being covered by this. At present, my lord, presently, I am being covered by this particular guideline that my lord, officers who are 52 years and above, they should not be transferred, my lord, beyond their homes.
Yes.
Home state. Now, my lord, next, while transferring officers, if it become necessary to transfer to outside places, such of those officers who have remained in the same place for a longer period are to be transferred first, having regard to other circumstances. My lord, the list I do not have that who have served, well, other officer who has served the home state longer than me, my lord, that list I do not have. That is for the bank to prepare, but that is, my lord, the secondary issue. Officers who have worked in rural areas for more than 3 years are to be considered for transfer to better places or higher areas if they so desire, subject to their overall performance being found satisfactory. This is not applicable in this case. My lord, transfer of lady officers not applicable. Inter-circle transfer I am not on. But, my lord, page 64, my lord, within the category of inter-circle transfer, the second paragraph reads, my lord, the officers are required to complete 3 years active service to be eligible for retransfer to home state. So, my lord, from 21 to 23, 24 now, my lord, I have completed that 3 years in Bhubaneswar, in Odisha. So, my lord, I become eligible to, my lord, for consideration to retransfer to home state. Therefore, thereafter, my lord, transfer to neighboring state. Officers working in neighboring states are also eligible for transfer to home state on completion of a normal term. My lord, normal term has not been defined, but I have, my lord, completed 3 years in the neighboring state. So, my lord, I humbly submit that this is also applicable in my case. And then, my lord, I am skipping to, my lord, page 67, which reads request transfer. Request from officers for a transfer to a place of their choice on the ground of sickness and compassionate grounds may be considered sympathetically. Such request transfers may be considered for 3 occasions in the service as an officer employee. My lord, the representation that I have submitted, my lord, shown, that is for the first time, my lord, I have prayed for, my lord, consideration that I may be posted in my home state. And
officer has the option to file
three times. So this was my first, my lord. I have never prayed for transfer or retransfer or, my lord, for consideration for not to be transferred. And, my lord, the other the clause that I am relying on is at page 69, my lord, SC/ST officers.
Okay.
It reads, my lord, all officer employees of the bank are eligible for transfer to any branch office and have all India transferability, As such, no separate rules, guidelines are laid down in respect of SC/ST officers. However, whenever any representations are received from SC/ST officers, such request may be considered sympathetically. My lord, I belong to the scheduled caste category.
Okay.
So, my lord, matter is, my lord, this short that I have made a representation. There are certain, my lord, safeguards in this transfer policy which have not been considered at all by the bank authorities. Now, my lord, even after I was being transferred to Bhubaneswar, I was again transferred to Bhadra. And again, my lord, I have pendency of the writ petition. I have made representation for, my lord, transferring me back to the home state. I have, my lord, shown the clauses where I am not saying, my lord, entitled, but, my lord, I have the, my lord, right to be considered at least by the bank authorities. My lord, that is my case.
Yes. Yes.
After discussion with the Canada Bank officers,
Association.
Canada Bank officers,
Association.
the joint conference, the bank has evolved the transfer policy of officer employees way back in 1980. Policy guidelines are periodically revised during the modification of the suit the administrative need and the requirement of the organization and also the aspiration of the officers in tune with the changing environment. In view of the context, we found it difficult to give the policy. So, what I read out, there is no, I found out that we have transferred the number of places as enumerated in my affidavit and opposition page number 4, paragraph number 5. And always the transfers have been made to the urban areas. Nowhere rural area has ever posted to the petition area. So the transfer policy, the mean, the answer is like 1 to 9 of page of the policy for officer enterprise, the policy guidelines, the modification and the development of the office. The transfer policy not only the benefit of the officers, but it also the requirement or the needs of the organization of the same. I will rely upon the earlier order passed in the by the market. So, transfer cannot be and can never be claimed by any officer, employee who has taken the employment now present scale to management. Scale 1 as done by scale 2 manager. For manager, he is well aware of the transfer policy. The service rules. Service, when he has entered on the service, from the day one he has given the circle of Karnataka, then Bangalore circle office, then Chhattisgarh circle office, then Kolkata circle office. Visakhapatnam Circle Office, Kolkata Circle Office, Kolkata. It has been posted. The one commission made by my friend was that it was never posted in Kolkata, but it was there in Kolkata. 2009. Then it 2012 to 2014. And then from Kolkata Circle Office, then Kolkata Circle Office in 21. The details of the transfer made to the petitioner are included in paragraph 5 of the document. Never he has been subjected paragraph 6. All details he has joined the service in 2001, and from that all the years. So he cannot give that he has never been posted or he has always been outside Kolkata region. Static posted in Kolkata region as available in my government code, Kolkata Circle Office from 2004 to 9. Then again Roman 6, Kolkata Circle Office June 12, 2014, October. Then again in Roman 8, Kolkata Circle Office. In the meantime, so the first of all, what my friend normally office who are illegal now will not be posted outside the state. When the petitioner was transferred in the year 2021, he was of 51 years of age. So as per the transfer policy, he can and he could be posted outside the state. Thereafter, it's required by my friend, President Calcutta of the bank, which has got which is in the year 2024. It starts from the page 29. From the policy of scale 1, 2, and 3 as approved by legal director in the year 71/2024. There is a recent transfer policy.
Page
29 of the application reply filed by the petitioner.
The reply filed by us.
29 onwards, the lead part starts on page 30. There are the same thing in regulation 47 of the regulation 1971 to the transferability. Detailed guidelines issued by documents. The transfer is everything same. The transfer policy is applicable to all officers in scale 1, 2, and 3. Each are there in the scale 1. So this policy is applicable to the petition. Transfers are required to various for various like exposure to bank and the various locations within the rotated or the country to prevent fraud to enable the officers to be back in the area. These administrative activities. Thereafter, it is all the same. Then I am talking to page 31. The second bullet. Let us start from generally the officers transfer from one place and we transfer from the application of 3 years under the branch officer expert of promotion by the officer can be found. Administrative activity they have on request of the administrative activity. They have not completed at least. However, the transfer shall be subject to administrative activities and available normally now there is a change from the 1995 regulation to 2004. Normally officers who are aged more than 54 years and above shall not be posted outside the home state. Now it is
54 years.
So the petitioner is now
53 plus.
First of all, petitioner has joined in August 2021. So he also has completed 3 years of service in August 20. All the situations presently after promotion at that time he was the one officer Now he is a scale 2 officer transferred to Patro, which is more nearer to Kolkata region. It's nearly 200 kilometers, then less than Bhubaneswar distance. So he is being transferred as a and he cannot take the transfer as an vacancy of availability of the officer, administrative agency, and all this has to be considered if every government officer come to the here on earth that I have to be transferred as per my vision, whims and fancies that cannot be taken into consideration. And as regard to the SPC, I am rejecting. The earlier also people said that they have to be considered strategically, but presently I am coming up with this page number 30 of the legislative this is the present transfer policy. Now it cannot be governed by the transfer policy of 1995. It will be governed by the one which is coming to effect in January 2026. Transfer of the first transfer of specialized officer which he does not need the general practice. So it is SPSP officer. All officer employees of the bank are liable for transfer to any branch office and have all India transferability. As such, no separate guidelines are laid down in respect of SPSP. However, whenever it is received that request may be considered. That is, request will be considered as a time arrived. The administrative transfer is not only to the officer and the requirement presentation. There may be 10,000 other officers who are governing something. See type of problem they have to be. There has to be some I must he the one petitioner there must be 100% petitioner employee who are under the order for transfer have similar grounds and requests. They have to consider. They have to be it is not that 21% have to be considered. That if he wants a posting in Barrack, not paper, Barrack or whatever, but they have to be a vacancy. Somebody from there also has to be transferred there. It is not that one transfer, it is the rotation of officers, which is the whole officers, top officers, scale 1, scale 2, scale 3, if one person is mobilized from one place to another person, the similar type of person, the type of officer has to be mobilized from there to there. So that also has to be taken into consideration by the management. It cannot be on the expenses and the requirement of the employees because we are entering employee taking to all the considerations that will be transferred at any time and every time. It is not that 3 years, 5 years, every 1.5 years, 1 year we can be transferred with the requirement of the bank, right? So everything will be governed by the transfer policy and what is related to administrative requirement of the bank and not without that. And B consideration of his Bhubaneswar posting, he has been presented, I believe, last month. In the month of May, he has been transferred to a nearer direction, that is in Bhadra, which is nearer to Kolkata. Maybe after completion of 3 years or 5 years, as per the requirement, his turn inability to get it back to the home state will come. And he will not be ineligible to get the benefit of 51 years or 4 years because earlier at the time of the transfer in 2021, his age of the cutoff age for non-transfer outside the home state was 52. That time was so he, as per the policy, he transfer. Presently, as transfer policy 54. Petitioner is 53. So petitioner liability of getting posted to home place may definitely arise after the year. First of all, after completion of nearly the list of posting,
and medical grounds cover the medical grounds. Page number 34. Sickness component grounds of sickness.
I am reading the order of 16 August 2021 passed by Honorable Justice Foreign. I am reading petitioner has not been joined the document.
Yes.
Immediately join the transfer the letter prima facie attest to right rejection of the petitioner prior to the view of the court has been very cautious and in the amount lawyer after hearing the parties the matter is accepted the application because next order is that 23rd August when the matter is three lines. It is submitted we have and point the transfer August 20. So if the transfer having missed on request or coming back will arrive on August 20. That also taking considering the transfer policy of the bank and the requirement of the bank. My submission is like all the cases of 1600
So the rural area will change. Your instruction means when to join it. No, how to say he was asked to go to the rural office. He was informed that he could join the rural office, not this.
Will arrive only after completion of 24 years. After 3 years, that is August. The ability bank will consider taking the list of the request transfer. Only one request transfer cannot be considered. The request transfers are also considered the seniority. This request will be considered. Hundreds of request transfers, and definitely bank will take into consideration all this and after completion. CLP transfer to further of criminal is definitely and we want to belonging to scheduled class category, no benefit or no special given as requested transfer other than being considered which definitely bank does, and moreover applications are there to to the matter, and so that will be done. So no specific when my permission and I will. And I just consider the earlier transfer policy filed. I have not filed any transfer policy. The regulations 47 of the bank has been filed twice by my government and very thankful for it. First time in the writ petition, that is the transfer policy of the year 1998 and second is 2024. All the transfers have to be governed under this because this transfer policies are formulated as per the post committee report and as per the meetings and the outcome of the joint deliberation between the managers and the officers. So officers association, all the managers, all the officers and other parties. Their grievances, their all the are being that has been considered and the policies that have been formulated that is very specific. If the as I have read it, that policies have been evolved after discussion with the officers as made out in the study of the transfer policy and limited the all the transfer policy, all the policy guidelines of the personal administration and with the deliberation, the management and the employers and the employees. There is the management as well as the officers. So, my submission and notice submission after 3 years, we stay under the Bhubaneswar Circle Office. It's under the Circle Office. But 5 years to the and he has not completed his tenure of 3 years in this legal.
Whether his representation was answered.
I'm grateful, my lord, because that is my case. My lord, I open my argument saying that this is a transferable job. Transfer is an incident of
Representation at
service.
page 32. Writ petition.
My lord, another representation is there, my lord, at page 20 of my reply. That was made in 20th, 29th of May 2024. My lord, right entitlement policy, the transfer applicability, enforceability of the policy, my lord, that is one issue. But my lord, I have a right, if a representation is made, my lord, I have a right that that representation be considered. My lord, I open my argument saying that this is a transferable job. I know, my lord, transfer is an incident of service. But my lord, if I make a representation and my lord, within the periphery of this transfer policy, if there is any provision, my lord, then the employer, my lord, is bound to consider my representation. My lord, that is what the Supreme Court is also saying. My lord, even if a transfer policy does not have a it's not legally enforceable, but still, my lord, if I make a representation, that has to be considered by the employer. My lord, where is this consideration? My lord, I will be, my lord, after 54 years, I might be considered. My lord, these are all speculations. My lord, if your lordship directs the employer to consider my representation, because all these are coming, my lord, after I have filed the writ petition. There is no single, my lord, letter to show that all my grievances have been considered, and after considering, my lord, they have refused it. This is nothing but, my lord, report to duty, otherwise I will take disciplinary action against you. This is a threat. This is, my lord, not consideration of the representation.
No, no, that cannot be. No, 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 no. You cannot argue like that in that fashion. This is another direction upon the employee to join at your transferee place. Yes, that is within the norms of the bank. Yes, you can direct the employee to join. But where is the reply to his representation? That one line actually sufficient that your representation can
Considered rejected.
Can No, this is not the letter dated 5th of July, where he made the representation to consider his
1st of July.
Thereafter, mails have been sent. All my 6th of July, thereafter the 5th of July, thereafter mails have been sent. That mails have been considered by the bank. If government clear have only sent mail, that is 3/8/2021, this letter, what my bank.
page 32.
I have been affiliated with all my medical records. So every definitely in July and thereafter on 10th of August, bank has definitely considered all the risks.
Very. And my lord, kindly sees that in 2024, this new transfer policy has been, my lord, formulated. And but the earlier transfer policy was, my lord, there till 2024. So, my lord, when I completed 52 years of service, this earlier transfer policy was in place. But yet, my lord, that particular clause that an officer who completes 52 years will have to be, my lord, transferred back to his home state was not considered. My lord, now 2024 policy has come that age has been raised to 54, and now I'll have to again, my lord, wait for another few months to complete 54 years of age, and then the bank says they might consider. And that too, my lord, then, my lord, there is no use of, my lord, formulating any transfer policy.
I understand the entire issue.
I'm grateful, my lord.
Only the question is whether you have considered the employee sympathetically. According to their rule, you have not considered. Whether his representation regarding the COVID pandemic period and whether it was answered, nothing.
From 21, thereafter, had joined the Minister office because thereafter, when the second representation came in the month of 2024 and May 2024, when it was again transferred to her. Prior to that 2 years, no representation was there.
My lord, the matter was sub judice, my lord. And kindly see page 20 of my reply. 29th of May, I have submitted again another representation, and that is awaiting consideration, my lord. এই ভদ্রকের ট্রান্সফার অর্ডারটা কোথায় যাবে? 29 না না 20 আচ্ছা না
Very well.
20 Lord, page 20, if your lordship may kindly consider, of my reply, my lord. This is another, the last representation dated 29th of May 2024, which has also not been considered by the bank. And I mentioned that I have undergone kidney stain surgery twice. Lord, I stand with my learned friend, my lord. That transfer is an incident of service. But, my lord, I have a right that my representation is considered in accordance with the policy.
Okay, that's all.
My lord, that is my case, my lord. And, my lord, the provision of my lord, request transfer is also there in the 2024 policy, that if on the ground of sickness, my lord, the bank has to, my lord, consider it sympathetically. Page 34 of the reply, my lord. So so, my lord, the policy of 98 and policy of 2024 is, my lord, more or less similar, my lord. Only the age that the 52 has been raised to 54.
Yes, always there.
Exigencies, my lord, always there. What is not there is, my lord, a one-page reply from the bank that I have considered your, my lord, grievances and I have rejected, or I have partly allowed, or I will allow. My lord, if that is the, my lord, submission, I have nothing.
The issue is that You have made a policy and you are not following the policy. What is this? For making policy for iOS or anything. When these are in question in the court, that has to be answered properly. No, that doesn't mean you have considered the main. No, that cannot be construed like that. You know that cannot be construed like that. Very well. Please take down.
ফিস দিয়েছি ফিউচার থেকেও নো রিপ্লাই ফিউচার থেকেও কিন্তু দিয়েছি এটা
There are 2022 facts have not been covered. So as my landed is 2024 and that is going to
Affidavit in opposition filed on behalf of the respondent is taken on record. Is taken on record. Reply by the affidavit in reply by the petitioner against the affidavit in opposition filed on behalf of the respondent number 1, 2, 3 within bracket bank is also taken on record. Full stop. Next paragraph. The present petitioner is a bank employee.
ওর ফ্যাক্ট গুলো যদি
Under Canada Bank. Initially, he was appointed February 2001. Thereafter transferred in several locations. Full stop. He was posted at Kolkata Circle Office from 7th day of June 2012 to 25th day of October 2014. Thereafter transferred to Durgapur Circle Office and again posted to the Calcutta Circle Office from 11th day of June 2018 to 23rd day of July 2021.
কলকাতা সার্কেলের মধ্যেই ব্যারাকপুরটা পড়ে বুঝে যাও না কি
On 1st of July 2021, কে নেবেন আপনি নেবেন নাকি ঠিক আছে নিন এই পার্ট দেখেন on 1st of July 2021 a transfer order was passed by the respondent number 1 to 3 by the respondent's authority directing the present petitioner to join Bhubaneswar Regional Office, Bhubaneswar Circle. Full stop. The said the alleged transfer order alleged transfer order raised some difficulty in the living of the present petitioner on the ground that he was 51 years of age at that time and suffering from different ailments. Furthermore, his daughter was suffering from acute lung disease and appearing in class 12 final examination. However, one representation was made by the present petitioner on 5th of July 2021. He also made a representation that due to the prevalent pandemic situation of COVID-19, he may be allowed to continue his service with his place of posting at Barakpur. However, he could not join the service, join the duty at Bhubaneswar. The office of the respondent number 123 forwarded specific intimation to the petitioner on 10th of August 2021, directing him to immediately join the duty at Bhubaneswar Regional Office, following which the disciplinary action will be initiated. By the dint of this communication, the present petitioner seeks intervention of this court. However, no interim order was passed in favor of the petition. Consequently, the petitioner joined his place of transfer at Bhubaneswar. Since then, the petitioner was engaged in the Bhubaneswar circuit. Initially, he was at Bhubaneswar, thereafter Kotok. Now he was posted at Bhadrak.
Not Kotok, from Bhubaneswar to Bhadrak.
Bhadrak. In the month of May 2024. अच्छा क्या बोला बोलो? Since then, the petitioner was engaged. Learned advocate for the petitioner next submits that the present petitioner is suffering serious physical ailments and now he is 53 years old. Full stop. He further submits that it is quite difficult for him to continue his service, but particularly due to his ill health. The respondent authority did not consider the representation of the present petitioner on the earlier occasion Since then, no. Where is your new representation?
My lord, my first representation is at, my lord, page 32.
And second?
Second, my lord.
Page 19.
Page 29, my lord. My lord, 20. এই 29 এর রিপ্রেজেন্টেশনটা কোথায় গেল? My lord, page 20. Page 20 of my reply.
Page 20, yes, got it.
19 and 20. I'm thankful, my
19
lord.
and 20. Both.
Thankful to my learned friend.
Yes. Yes.
On the earlier action, says then.
Now, still, but the present petitioner, with his usual fairness, again submit two representation on 22nd of March 2022, as well as 29th of May 2024, for transfer him to Kolkata Circle on health grounds. Those two representations were also not considered by the respondent authority. Planet Airport petitioner further submits that the necessary direction may be passed upon the respondent authority, so that the present petitioner may be transferred from the Bhubaneswar Circle to Kolkata Circle. The petitioner also referred the transfer policy of the respondent bank, wherein it has been specifically mentioned that generally transfer of officer, generally transfer of officers from one place to other can be considered only after completion of 3 years service at branch. 3 years code, 3 years of service code, unquote. He also, learned advocate for the petitioner also pointed out the transfer policy for the year. It is the initial policy.
My lord, initial policy, my lord, in my writ petition.
1998.
Page 62.
Yes, 1998. He also pointed out the 1998, wherein it has been mentioned that within quote unquote, normally officers who are aged 52 years and above will not be posted outside the home state except on promotion, unquote. ওটা ভুবনেশ্বর সার্কেলটা তো ভদ্রকের মধ্যেই পড়ছে, ওটা টোটাল ভুবনেশ্বর সার্কেল। Okay.
Because I am against the request transfer clause, my benefit right. Just below that, there is a lapse of request for transfer, which was there earlier also.
Yes.
The officer makes a request for transfer and if it is not acceded to, such request shall lapse after expiry of 1. There is one that may be referred in the office. If any request is there, it is not mandatory. But if it is not considered, then it will lapse after 1 year, and after 1 year, again a representation has to be made for the request transfer for the subsequent transfer period, that is May, June.
In this case, my lord, there was no intimation that the request was not considered.
No, I'm just mentioning the what are your norms in the transfer policy?
That is what the
request transfer in 24.
Request transfer is
request transfer, and below that lapse of request transfer.
Lapse of request transfer. Okay.
request transfer, that also.
Okay. Learned advocate for the petitioner submits that in the has filed the transfer policy for the bank for the month of for the year 2024, wherein the age as mentioned above for the officers, for the old age officers, was converted to 54 years from 52 years. Next slide. Learned advocate for the petitioner also mentioned the clause of request transfer in the transfer policy itself, as well as the lapse of request for transfer. It as follows. Page 34 reply. Page 34 and 35. এইটুকু দেখেন এইখান থেকে এখান পর্যন্ত মার্ক পোর্শন, ঠিক আছে, লাস্ট 34 লাস্ট 35 এই দুটো এইটুকু। It is further submitted on behalf of the petitioner that petitioner belong to SC category employee, and there are a provision in the transfer policy regarding the SC/ST officers as follows. Page 38 of reply. Marked. Next one. Learned advocate for the respondent bank submits that the transfer itself is attached to the service. Full stop. The present petitioner is in service for a long period. Full stop. He must have known the norms of service as well as the transfer of any bank employee from one reason to another reason. It submits that the transfer of any employee from one reason, one circle to another circle only made due to the administrative requirements and exigencies. Full stop. The transfer policy and the transfer of the bank is dependent upon several considerations. See, further submits that the transfer of a employee from one circle to another required to replace by another employee to another circle required to
from one circle to another circle.
Requires the posting of another employee of same nature and scale. Full stop. The present petitioner is now under scale 2 officers. So his transfer from Bhubaneswar circle to Calcutta circle requires one person of same scale to be posted, promoted to scale 2 officer. So he's transferred from officer of same scale be deputed at its place at Bhubaneswar Circle. Full stop. The function of the bank is to smooth performance of the service, so the transfer policy cannot be challenged anyway. Are the learned advocates peruse the transfer policy of the respondent bank for the year 2024. It appears that the present petitioner has made 3 representations.
Two thereafter.
No, initially one.
Yes, initially one and thereafter two.
Yes.
22 one and 24 one.
Made 3 representatives to the bank authority, but none of them was answered by the respondent authority. I make it clear that the respondent authority has formulated a policy of transfer, but conduct of the respondent authority disclosed that they are not actually following the policy properly. Considering the entire aspect, I think it necessary that the case of the present petitioner need be considered sympathetically. Under the above observation, the present petitioner need be considered by the sympathetically by the bank, by the respondents according to the present transfer policy. Full stop. It appears that the request transfer application, it appears that the representation for request transfer has already been made by the present petitioner, which has been reflected in page number 20 of the reply on 29th of May 2024. The period of such representation and request has not been lapsed according to the policy. Stop. Thus, the respondent authority is directed to consider the representation of the present petitioner dated 29th May 2024, so that the transfer policy of the bank for the year 2024 may be adhered strictly. Full stop. I make it clear that I have not considered the other parameters of availability of vacancy and administrative exigencies of the bank, but as the request has been made on behalf of the petitioner and consequently which was not considered by the bank authority, thus this court constrained to pass a specific order so that the present petitioner may be transferred to his home state. Also, under the above observation, no. The respondent authority is further directed to dispose of the representation of the present of the petitioner dated 29/5/2024 within 3 weeks. Within 3 weeks. Within 3 weeks.
My lord, this is the transfer season, May, June. Maybe 2 months time, maybe.
2 months already arrived. What?
It has been favorably considered. If my lord see page 20, it is favorably considered by General Manager Bhubaneswar, my lord. This representation was considered by favorably considered.
Okay, then
no
what time you 4 weeks? 4 weeks.
For
4 weeks.
consideration and
Yes.
necessary.
Because
Because one part he has cleared. He has been favorably considered by Bhubaneswar.
okay.
There is only that the representation of the petitioner dated 29
5, 2024,
Hmm.
within 4 weeks. Within 4 weeks from date, the decision of the concerned authority shall be intimated to the petitioner within 2 weeks thereafter.
I'm grateful.
Under the above observation, the instant petition is disposed of.
I'm grateful.
Connected applications, if pending, are all disposed of.
And I tendered my apology to my lord because I had questions for Passover wherein I couldn't come from net recovery.
Okay. No issue. No issue. No issue. Huh? That one? Call next matter. Item number 13. Please take down. An accommodation is sought for on behalf of the petition respondent. According the matter is urgent today. Please the matter on 12th of July. And the same meeting. Next. Order book. Not today. All matters conclude. Yes, whatever you want to submit.
Lordship, may I be permitted to mention OD2, Lordship, which had been mentioned in the morning and taken up at 1 p.m.
Yes, I have took up this matter.
Lordship, may kindly just record my appearance, Lordship. We are appearing for the respondent.
Fine, good. Server has been mentioned. You must have mentioned in the first half.
Lordship, we appeared and due to technical glitches, we could appear at 102. Matter was taken up at 12:57. We appeared but couldn't make submission. We appeared at 102, Lordship. That is the entire difficulty.
Yes, I have left the appellate side 12:58. Thereafter they arrange, and I take up the matter only.
Lordship, may kindly appreciate we are appearing for a PSU. That is the entire
no issue.
difficulty.
You come on next day. You mention it that I was there, but I will mention your name in the server on the next day that you will appear in this matter.
Lordship, actually the only problem is it's a PSU, Lordship. That is the entire difficulty. They are very. May I check, Lordship, whether it has
If
been.
server is not done, then I will accommodate. No.
May I take 2 minutes, Lordship, to check?
আমি করে দেবো সই করে no issue. যদি সার্ভার না হয়ে থাকে নিয়ে নিন ওটা. Yes, give me the list. If the server is not met, then I.
Lordship, may I take 2 minutes to check? I've opened the website, Lordship. Just 2 minutes, Lordship. WTO. Yes, Lordship.
Server has been done. Server done. Okay. So you do one thing. When the date was fixed? In the server, it was 26th.
26th of July,
On
Lordship.
26th, I will pass a order that you have appeared in the today. Okay.
Obliged,
Separate order becomes no issue.
Obliged, Lordship.